African High Commission in Tanzania that the mission, the South African mission in Tanzania, is South African soil, and that South African law applies on that soil. Now that's just wrong under international law. A foreign mission is not the territory or the soil of the sending state. It will remain Tanzanian law throughout. There are certain principles under international law, in particular Vienna Convention on Consular and Diplomatic Relations, which talks to what the nature of that territory is. But once that principle, relied upon by the respondents, is demonstrated to be false, and the true law is, as we would have it under international, and I'll turn to it, that would be, we would suggest, the end of their case. There's another aspect of the Chapter 2 is the proper interpretation of Section 41 of the Immigration Act, which Mr. Matthews relies upon. And we say that that reliance is misplaced, and that would also be the end of his case. The third chapter is one in which we interrogate and drill down deeply into what the facts are. And in my introductory chapter, I'll suggest and submit that the facts that your Lordship will take into account for determining this case are those facts put up by the respondents. That which the applicant says is interesting, and it may be correct, but it's irrelevant for your purpose, your Lordship's purposes, on the basis of certain principles that I'm going to come to. The fourth chapter will be a chapter articulating the law, and in particular, that where there is a deportation which has the effect of extradition under international, that's called a disguised extradition, and that is unlawful under international and certainly under the South African Constitution. And then the last chapter will be our conclusion, and what we would submit would be the appropriate remedy. Your Lordship would note that I haven't dealt with in this introduction, in these 5 chapters, with notions of urgency or with notions of strikeout. We would submit that the notion that a matter in which somebody is in custody and brings a case to suggest that their custody is unlawful is not urgent, is without merit, bearing in mind the full conspectus of the facts. And we refer to cases in particular in the refugee context, in the immigration context, in South Africa, where persons are detained, and the courts have said, where there's an allegation of unlawful detention, that detention should not continue for 1 second longer than necessary. And were your Lordship to, for example, strike the matter from the roll for want of urgency, what would happen? We'd be back here in 3 weeks' time. And then we'd be arguing whether the applicant is unlawful custody. So we would submit there's no purpose to be garnered on the question of urgency. There's also a strikeout. We have little to say about the strikeout because it relates to certain paragraphs as we understand it and annexes of our replying affidavit, and it takes the case no further because, as I've said, it will be the respondents' papers that would demonstrate why we're entitled to the relief that we seek. Now let me turn to the first chapter, which is the introduction. When it comes to the facts in opposed motions in which final relief is sought, it is almost a truism that Plascon Evans dominates. So Plascon Evans tells your Lordship, as we understand it, that your Lordship would look to the facts contained in the answering affidavits, together with those facts in the founding papers, which are not denied by the respondents, to determine what are the facts that your Lordship must have regard to. And we're going to submit that the facts as set out in the answering affidavits demonstrates that our client is entitled to the relief that she seeks. Now, my Lord, may I just start off and link Plascon Evans to where's the onus in a case like this, and how does the onus work, and when does it shift, and what's the prevailing law on that? Now, we would submit, my lord, that the leading case on questions of onus when it comes to detention, and let me emphasize the following words, an allegation of unlawful detention. Zealand will be your guiding light as far as that onus is concerned. And we've got a quote from Zealand in paragraph 8 of our heads of argument, and I'd like to read the quote, because it talks to what an applicant needs to, and we emphasize plead. And an applicant, all that an applicant needs to plead is that she is unlawfully detained. That's all she has to say. She doesn't have to explain why. She doesn't have to make out a prima facie case. She just has to plead it. And the onus shifts to the respondents to set out why the detention is lawful. And that one sees, perhaps I should, I may take the Lordship to our heads of argument on that aspect, paragraph 8, because there seems to be some, not agreement with our learned friends, but there seems to be some suggestion that just to plead it is not enough, and they have the kinds of arguments, well, she says she was blindfolded, she wasn't, and a whole range of arguments which we submit at this point has got nothing to do with the case. So her allegations, even if the court rejects them, are unhelpful to how this court will decide the question that is before the court. So in paragraph 8, we quote the position as explained by Lange CJ, and he says the Constitution enshrines the right to freedom and security of the person, including the right not to be deprived of freedom arbitrarily or without just cause, as well as the founding value of freedom. And then the important sentence, two sentences. Accordingly, it was sufficient in this case for the applicant, that's Mr. Zealand in that case, to simply plead that he was unlawfully detained. This he did. The respondents then bore the burden to justify the deprivation of liberty, whatever form it may take. So it's a pleading point. And once we accept that, we get to the questions as to how the respondents have attempted to justify the applicant's detention. And they make a whole series of side swipes that she has not come to court with clean hands, etc., etc., and she hasn't told the truth, and therefore she hasn't made out a case. But of course, that's not the law. Perhaps I should just read further on that point. In paragraph 9, as he said, a respondent, that would be the police, the NPA, and Home Affairs, will often be armed with all the facts concerning the alleged illegality. They are required to place these facts before the court because it's likely to fall within their exclusive knowledge. And similarly here, my lord, the applicant gets arrested on the 6th of April, 2023, in Tanzania. She has a perception of what happened. But it's within the respondents who are holding her knowledge of what happened from when they heard about this arrest on the 7th or 8th of April until, on their version, she was arrested at Lanseru Airport on the 13th. It's within their knowledge. And they tell us, or they tell the court, this is what happened. And I will drill down into what they say happened. But what happened?
You are, sorry, Mr. Katz, you are now still dealing with the aspect of onus.
Onus, as these.
Yes. Is the fact that we are dealing here with motion proceedings, does that have any effect on the onus? Doesn't onus, the question of onus arise in motion proceedings?
In Zealand was also in motion. Zealand was a motion, and he asked for the declarator that his detention from a certain point to a certain point was unlawful. And and the question then becomes, in that case, which was a motion proceeding, the Constitutional Court determined that there was an onus on the respondents to justify the detention. And I was coming to the next case that in our heads of argument, which is Jibai, judgment of the Constitutional Court. SCA. And on the top of page 8 of the heads, I mean, this is a case in which the person was removed from South Africa or disappeared out of South Africa. But it's the principles that are at stake. It was a motion. Similar motion, it came before the full bench in Gauteng, went up to the SCA, and the SCA said the following: in upholding the appeal, an act of deportation does not necessarily involve the loss of the deportee's liberty, but it usually does, as in this case where it is preceded by arrest and detention. And then the important sentence that we've underlined. And because every deprivation of liberty is presumptively unlawful, the respondents bear the onus to adduce sufficient facts to justify their actions. It's a similar point to zero. So if your lordship puts to me, well, is there an onus in motion proceedings unlike in an action? We would submit that in these kinds of cases, there is an onus, yes. An onus is borne by our learned friends, to the respondents, to justify the illegality. And the next sentence, my lord, I'm told to read, it answers you directly. This is so also in motion proceedings. And that answers your question directly. I must thank my learned junior for bringing that to my attention. And that was an exception to the general requirement that the applicant must disclose its entire place in the founding affidavit. And then he explained why that is the case. Are you with me, my lord?
Yes, I hear you.
Now, my lord, I've made 2 points as part of the introduction. One is the Plaskon-Evans proposition. 2 is the Zealand proposition, together with the Jibhai. And together with that, I want to make the point that your lordship can decide this case, and we would say it should decide and must decide this case with reference only to the facts that the respondents put up. You don't need to go to what the applicant says. That's how we would suggest the cases are to be read. So whatever the applicant says in the founding papers, in a replying affidavit, gives context but no more. And when your lordship looks at the conduct of the respondent through this lens, we would submit that you would look at it from an objective perspective. It's not a question of subjectivity. Did they comply with the law on their version? And they put up why they complied with the law. They put up why the detention, the current detention, and the leading up to it is lawful. And your lordship will consider, is their justification objectively good or bad? And we submit it's bad on their version. Now, my lord, I want to go to a third point, which is what I call the Fedsure point, which is a point that says that under the Constitution, no power may be exercised other than that which has been provided for in the Constitution or law. No official in the South African state may take any action unless there is a provision which gives that official the power, the authority to exercise that power. If the official acts outside or without the authority contained or provided for in the Constitution or the law, that official acts unlawful. I don't think that's a proposition that our learned friends would quibble with. But if I can demonstrate to your lordship that what happened in this case, and I will, included conduct by any of the South African officials outside the law, they acted unlawfully in that period of the 12th to the 13th of April, when our client was, and I use the words, their words, not our words, handed over. And just on that, I'm giving you Fedsure, it's in our heads, but perhaps your lordship could turn to our bundle of authorities on page 136, the paginated bundle. There's reference to a case called Mohammed. Mohammed versus the President of the Republic of South Africa and others, 2001, volume 3, SA 893. Constitutional Court judgment of the whole Constitutional Court. It concerned the removal, and I use the word removal advisedly, of Mr. Mohammed from South Africa to the United States, where he was to face the death penalty. And a whole range of questions arose concerning whether the removal was a deportation or an extradition, and ultimately the court found that it didn't really matter because whichever it was, he couldn't lawfully be sent to a country in which the death penalty was available. There's a whole range of principles that come out of this judgment, unrelated to the death penalty. So your Lordship can put the death penalty issue aside and perhaps just take cognizance of the following principles. On 136, in paragraph 31, the Constitutional Court made what I would call the Fed-Sure point. It said the position in this country, South Africa, must be considered in the light of the Constitution and the relevant legislation. In Hugo, this court, the Constitutional Court, came to two important conclusions regarding prerogative powers under the interim constitution. Hugo was a case where President Mandela, as part of a birthday celebration or something, had given freedom to a number of people in prison. And they were mothers of children who hadn't been in convictions and related to violence. And Hugo was a man. He sort of violated his rights, because why should a woman get something that he would have been entitled to if he was a woman? And the Constitutional Court dealt with it. But there, the Constitution talks to this question of prerogative powers. And what is said in paragraph 31 and following is that there is no power, for example, to deport somebody other than in a piece of legislation such as the Immigration Act. There's no power to pardon somebody. There's no power, for example, in the Mohammed case, to deport him to the United States or to extradite him without a power. That is said in paragraph 32. Well, at the end of 31, it says that this subsection does not provide for any power to deport an alien. Accordingly, the state's power to deport relevant to the present can be derived only from the provisions of the Act.
That is, sorry, Mr. Cat. That is why I understand your argument to be that what happened here is that here was a deportation that was disguised as a extradition.
I'm making 2 points.
Is that the point you are driving?
I'm driving at 2 points, my lord. The first argument is the whole scheme, and I'll come to it when I drill down to the facts. We will show that this deportation from Tanzania was a disguised extradition in the sense that it was collusion between the South African officials and the Tanzanian officials, where they tell your lordship it was an agreement to deport. An agreement, and we emphasize this word agreement. The Tanzanian officials, the South African officials agreed to something. That is extradition par excellence. Deportation is a unilateral act. So when the South African officials say, we've got nothing to do with this. This was Tanzania exercising its own sovereignty, a unilateral act. Your lordship will scratch his head and say, well, why was there an agreement between these two countries? And just on that, if you turn your lordship's eye up page 136, you will see what I've just said in context. And I'll turn to my other point about the Fed-Sure prerogative point after that. But what he said at the top of the page in paragraph 28, in principle there is a clear distinction between extradition and deportation. There is a reference to a number of books. And then he said extradition involves basically three elements. Acts of sovereignty on the part of two states. Two states, we emphasize two states. A request by one to another state for the delivery, and the delivery of the person concerned for trial or sentence in the territory of the requesting state. And then there's that's extradition. Three elements. Then it tells you, the court tells the world, deportation is essentially a unilateral act of the deporting state in order to get rid of an undesired alien. The purpose of deportation is achieved when such alien leaves the deporting state's territory. Importantly, my lord, the destination of the deportee is irrelevant for the purpose of deportation. The facts here demonstrate clearly on any version, this was extradition. That's it. That's our case. I could actually sit down now, but I'll need to drill down to the facts. Let me just add to so that's our case. Nobody can get away from what happened here. The police had an 8-member team who, in their words, deliberated with the Tanzanian officials as to the way forward. That was on the 10th of April. On the 12th of April, perhaps I should just turn to the words right now. What happened on the 12th of April, and I'll turn to 2 paragraphs on the papers. Mr. Matthews tells the court on page 172, paragraph 28, Mr. Matthews says the following words. Mr. Matthews, your Lordship will recall, is the Chief Director, Inspectorate, Immigration Services in the Department of Home Affairs. He says, I'm advised that as a matter of international law, an agreement was reached between the Tanzanian authorities and the South African High Commission regarding the deportation, in accordance with international protocols. He tells the court an agreement was reached. And then, to just nail that down, Miss Nao Teresa Moran, her affidavit is found at 207, and on page 210, paragraph 13, she says the following. The agreement in deportations, there's no agreement between states. Just read to you from the Constitutional Court. Agreement is extradition. But then she goes further. The agreement between the Tanzanian authorities and the High Commission, and the court will recall it well, she is the 3rd Secretary, I think it is.
Yes.
In the employment, yes.
Yes,
3rd Secretary. And the High Commission to deport the applicant back to South Africa was reached at the premises of the High Commission. So on the High Commission's premises in Tanzania, there was an agreement reached to deport the applicant. And then she says, I'm advised that once that happened, once the agreement was reached, the applicant, as a matter of international law, was regarded to have been in the custody of the High Commission on South African soil.
Does a deportation means that you are deported to a specific country?
I've just read to your Lordship, and perhaps I should read it again, paragraph 28 of Muhammad. Deportation is, this is on 136 of the bundle. Deportation is essentially a unilateral act of the deporting state in order to get rid of the undesired alien. The purpose of deportation is achieved when the alien leaves the deporting state's territory. An important sentence which answers your Lordship's question direct. The destination of the deportee is irrelevant for the purpose of deportation. It's irrelevant. It's destination neutral. As long as there's a, let's call it a kicking out, deportation is achieved. There can be no question of agreement to deport to a particular destination. Once that language is in the respondent's answering affidavit, it's the end of the case. So we would submit, my Lord, this is part of my introduction, I've diverted somewhat, but we would submit that's clearly one, unlawful as a matter of international law, and we've given the court the international authorities from various bodies, the United Nations Human Rights Committee, that explains why this is unlawful, the House of Lords, etc. But my Lord, your Lordship doesn't have to go to those fancy bells and whistles cases, because under South African law, whether it be executive action or administrative law, your Lordship knows any action taken by an official, I've already made this point, needs to be sourced in law. But also, even if it is sourced in law, it can't be a stratagem, it can't be for an ulterior purpose. What else was this? This was clearly a stratagem to achieve a result for particular purposes, ulterior purpose. So we would submit that on any basis, international or otherwise, this falls foul of the Constitution and the law. My Lord, let me go to the second chapter because it's not unimportant. I've debated this with my colleagues and they're not, they agree with the point, but they're not sure how it fits into the big scheme. And let me answer how I understand the point fits into the big scheme. If your lordship is not with us on this grand idea of this was a disguised extradition, which we submit, it's very hard to think of why you wouldn't be, because we haven't got any answer from our learned friends as to why this wasn't a grand disguised extradition. Then your lordship will have to consider the following. On what basis were the police, on what basis were Home Affairs in Tanzania, what were they doing there, and where did they get their authority from? And it's a strange answer that your lordship will find. And this was the answer from Home Affairs is found because my attorneys had written a letter to say, what was the Home Affairs authority? They were there. They insisted on joining this case. Home Affairs insist. Why were they there? And Mr. Matthews tells the court why he was there. Not why. He tells the court the basis upon which he was in Tanzania. On page 169 of the record, Mr. Matthews, under heading, says deportation of the applicant. And he has a whole series of paragraphs which explain. He starts off by saying on the 12th of April he was advised by the DG that he'd received a telephone call from the South African High Commission in Dar es Salaam that the Tanzanian authorities had issued notices declaring the applicant and investor as prohibited against. And then the important point, my lord, liable to be deported back, and I suppose there's a typo, to South Africa. It doesn't work that way. I've explained, the Constitutional Court has said, you don't get to be liable to be deported back to some place. You're liable to be deported, which means out you go. You can't be deported to somewhere. That's not the law. In terms of the Tanzanian immigration laws, and the Tanzanian immigration laws, they attach the particular section 25, and your lordship knows our argument that even under the Tanzanian laws, which your lordship doesn't have to go there, the applicant was not deported lawfully in terms of their law. But you don't have to go there. It's not for your lordship to consider that. So then
what does the, sorry Mr. Katzel, what does the notice says that the notice of deportation, if I can call it as such, it mentioned that she must be out of Tanzania in 3 days' time. But did it say that she must be taken back to South Africa?
No. Doesn't say that at all. It said, it's on page 202. The only time the word South Africa is mentioned is the nationality of the applicant and the place of issue of the passport. No destination mentioned on the prohibited area. So that's why I say, when Mr. Matthews tells you what he does here in paragraph 18 on page 169, it's not true. He says he got a phone call. I don't know, I can't speak for the phone call from the High Commission to him. But what I can say is whatever, if the High Commissioner told him what he said here, then the High Commissioner was wrong. Cannot be liable to be deported back somewhere. And the notice doesn't say that. But let me just go on, my lord. In terms of the notice, this is paragraph 19, the applicant was declared a prohibited immigrant, etc. And then there's references to sections of the Tanzanian immigration law. And then, in 20, the DHA, Department of Home Affairs, was required to provide air transportation for the deportation. And it was decided that, importantly, my lord, and this is his words, their handover. No handover in deportation. Handover is a concept essentially in extradition matters. Will be done in terms of the immigration laws, the Vienna Convention of Diplomatic Relations and International Protocols. And I just want to drill down into the next 3 paragraphs. Well, this is the second point of my chapter on the question of the unlawfulness question. That's even if your lordship rejects the question of disguised extradition as stratagem, in any event, they acted unlawfully on their version. So what happens then on paragraph 21, they say on the same day, on the instruction of that, the 12th of April, the instruction of the DG, the DHA hired a private aircraft as requested by the Tanzanian Immigration Division. I took immediate steps. He obtained 3 quotes from the relevant companies, presented to the DG, and then there's the invoices. Then he goes on. In view of the reports that Best orchestrated an audacious prison escape, etc., I decided to enlist the services of a special task force of SAPs. This was not foreign. Leave aside that for a moment. But the important paragraph is the next one, 23. And this is where he tells the court, Mr. Matthews tells the court the power that he relied on, authorization, the section authorizing him to do what he did by going to Tanzania and doing what he did there. It says, in fact, section 41 of the Immigration Act places the responsibility of performing statutory functions and powers on both the immigration officers and members of SAPS. So his reliance in this case is on section 41. There's no more. He doesn't mention any other section. And we've given section 41 to the court in our heads of argument. But it's just as well to turn to the bundle. Because in our bundle, on page 29, and 31, 29, going through to 31, we've got extracts from the Immigration Act. And when I read section 31 to your lordship, you will see it's a nonsense to say that what Mr. Matthews was doing in Tanzania could possibly be regarded as in terms of section 41. And once your lordship comes to that conclusion, then your lordship must find that what Mr. Matthews was doing in Tanzania was unlawful. Leave aside all the fancy disguised extradition stratagems. On his own version, he tells the court, I was relying on a section 41 to do what I did in Tanzania. Your lordship will look at section 41 and see, does it make sense? Is he correct? And the answer is no. Let's see what it says. 41's got 2 parts. 1, when so requested by an immigration officer or a police officer, so he says that in his answering affidavit, any person shall identify himself or herself as a citizen, permanent resident, or foreigner, and if on reasonable grounds such immigration officer or police officer is not satisfied, the person is entitled to be in the Republic. Such person may be interviewed, etc. And such immigration officer or police officer may take the person into custody without a warrant. What's the section about? It's about when the immigration officer or police officer is walking around the streets of Bloemfontein or wherever and sees someone who looks a bit dodgy from a that's the word that they use in Cape Town, where I'm from. The person looks dodgy from an immigration perspective. He calls the person over and he says, identify yourself. And show me that you've got permission to be in the Republic. That's what section 41 does. It doesn't allow for Mr. Matthews to jump onto a hired chartered plane, arrive in Tanzania, and go and interview people who may or may not be South Africans. That's not section 41. But he says he can use 41. Why? Because the agreement that was reached, it's actually laughable, but if it wasn't so sad, it would be laughable. But so what he says is, he could do it in Tanzania because the South African Commission in Tanzania was South African soil. That's what he says. But he didn't do it himself. Firstly, the South African Commission in Tanzania, I'll turn to this now, my next point, is not South African soil. Perhaps, we were consulting last night with one of the people, who's an attorney, said, people have this idea that foreign embassies and missions, consulates, are the soil of the sending state. And I said, no, that's not the law. And he said, maybe he's watched too many movies where you see these people running to the embassy, and they try to get into the embassy, and once they're in the embassy, they're safe from what's going on in that country. It doesn't work that way. That's a movie point. The law is the soil of the mission or the embassy is the soil of the host country, and it remains so. It's not South African. South African law does not apply in the mission. So even if, in some strange world, Mr. Matthews could come along and say, well, I entered South African territory in Tanzania in the mission, which he didn't, and there I looked at the person, I said, please show me your identity. Do you have permission to be in the Republic? Then maybe some strange looped chained argument could happen. But he's wrong on every single one of those loops. Firstly, this applies to in the Republic, and he certainly wasn't using Section 41 to determine whether the applicant or bester were entitled, these are the words, entitled to be in the Republic. That's just not true. Now turn to this question of South African soil. And before I turn to it, just let me turn to what he says, Mr. Matthews. He says that, and perhaps I should ask your Lordship to turn to page 172 of the record. He says in paragraph 30, he says, these are his words, I'm advised, as a matter of international law, once the handover to me, so we know that Commissioner, Tanzanians handed it to the Commission handed it to Commissioner, handed it to him. At Kilimanjaro Airport in Arusha, I'm advised that as a matter of international law, so he tells the court his understanding of international law, his advice on international law. Once the handover to me was completed, the applicant and bester were regarded as being on South African soil. What he says. Now, firstly, it wasn't on the mission's premises. So as a matter of fact, he's just got it completely wrong.
That was on the airport.
At the airport. At a different city. So it's not on the mission. How can that be possibly South African soil? Kilimanjaro Airport in Arusha can never be on South African soil. Just a nonsense. But then he says, therefore he says, it's important to hear what he says, contrary to what applicant's attorney suggests in his letter, it's the letter I mentioned to you, Lordship. He says, I could exercise statutory powers in terms of South African immigration laws, and in this regard, legal argument will be advanced when the matter is heard. Lordship hasn't seen any written legal argument in this point. But he tells the court that he, Matthews, South African immigration officer, could go to Tanzania and exercise his statutory powers in terms of South African immigration laws, because it seems to us that when the handover took place, he was on South African soil. Then the third secretary makes the same point. She says on page 209, she says, the previous page, she talked about the Vienna Convention on Diplomatic Relations, which South Africa is a party, talks about the premises of the mission being inviolate. But then she says, in simple terms, the premises of the High Commission are regarded as the South African soil, what she says, as the South African soil and property, that of the government of the Republic of South Africa. And attached to her answering affidavit is the Vienna Convention. That's her version. Now, she doesn't say, and she can't, that anything happened on the territory of the mission other than the agreement that was entered into between the Tanzanian authorities and the South African authorities. So that's what she says. Now, let's just analyze as a matter of law. Is it correct that a foreign embassy or mission is indeed territory of the sending state? And for that I'll turn to page 191 of our authorities bundle. Now I'll just interrupt myself, my lord. I'm going to, before I turn to this conclusion on this, your lordship, I don't even know if I need to make the point, but South African law doesn't extend beyond the borders of South Africa. Kaunda said, the Constitutional Court made that point in Kaunda. We've given that to your Lordship in our heads of argument.
Is that on 199, 191?
191.
Yes, thank you.
This is an extract from the textbook. We have a copy of the textbook as a whole, which we could hand up. It's the 5th edition of Dugard's International Law, a South African perspective. The 5th edition was 2018. We've given a couple of extracts from the book in this bundle, that if your Lordship would like to, let's call it, borrow the book or have the book.
No, it's okay, thank you, Mr. Katz.
It's a nice book.
You think I should read the whole book?
Well, I think you should read, perhaps you should read the parts that relate to this case, but I'm going to try to take your Lordship to the parts.
Yes.
Which is on page 191. The court is dealing with this question of diplomatic missions. And in little a on page 380 of the book, Professor Dugard explained that in order to enable a diplomatic mission to carry out its functions, Article 22 provides that. That's the article that the Third Secretary referred to. Other articles provide that the archives and official correspondence of a mission are inviolable and that the mission may freely communicate with its own government and other missions and consulates of the sending state. Remember, in our case, the sending state is South Africa and the host state is Tanzania. And there's reference to a case concerning United States diplomatic and consular staff in Tehran, which your Lordship doesn't have in this extract, but it is in the book if your Lordship changes his mind. But anyway, the point is this. Diplomatic missions use a diplomatic bag to transport diplomatic documents. And then we go down on the page 381. Well, at the top of the page, in recent times there have been a number of instances of serious abuse of diplomatic premises and the diplomatic bag by missions. In 1984, persons inside the Libyan mission in London fired shots at demonstrators outside the mission, killing a policeman. We leave that aside. But at the bottom of the page is the important paragraph for our purpose. B, extraterritoriality of missions. The inviolability of the diplomatic mission led to suggestions, this is because of Article 22 of the Vienna Convention, that it was accorded a special status by the receiving state because it was an extension of the territory of the sending state, that it was extraterritorial. That's what your Lordship hears from Mr. Matthews and from the Third Secretary. South African soil in the middle of Tanzania. And then he goes on. The explanation for the inviolability of the mission is no longer accepted. And there's a reference to V.J. van der Merwe, 1987, and various other references of case in England, 1972, and S versus Mara Para, 1986 case. Instead, it is generally accepted that the inviolability of a mission is based on functional necessity, that such inviolability is necessary to enable the mission to perform its functions. And now we come to the kicker, the real end of the debate, for purposes of South African law. This extraterritoriality theory was firmly repudiated by Groskopf J. in Santos v. Santos. There's a reference, 1987 case. When he held that a marriage solemnized in a foreign embassy or consulate by a person, in this case a Portuguese vice consul, who was not a recognized marriage officer under South African law, was invalid. The judge accepted the view of Michael Ackhurst, who's a famous professor of international law, footnote 212, 213, a modern introduction to international law, 1982, that diplomatic premises are not extraterritorial. Acts occurring there are regarded as taking place on the territory of the receiving state, not that of the sending state. So now I end my chapter 2 by saying section 41 has no place in this case. It's a section that Mr. Matthews relies upon to suggest that he had the power to do whatever he was doing in Tanzania. That's simply wrong. And you've heard no argument, or do not, you haven't read any argument contrary to that. 2, both he and the Third Secretary explain away all of the difficulties by saying this thing, whatever the thing is, and we'll talk about that thing in a moment, happened on South African soil. Well, it didn't, because South African soil does not exist in the Republic of Tanzania. Number one. Number two, whatever the thing is, and the thing can be a number of things, it could be the handover. The handover didn't occur on the mission. It's territory, premises. The agreement that was entered into, it might have happened at the premise of the mission, but so what? So we submit that on those two legs, were your lordship to reject the disguised extradition, the Muhammad point, the respondents fail miserably on this question of no power, the Fed-sure prerogative point. Section 41 is no cure to their difficulty, and the South African soil problem, Santos v. Santos, and the other cases cited in the Dugard book. So now I turn to my third chapter. And in my third chapter, I'd like to just flick through the facts. Now, your lordship knows that the facts, your lordship, I do not intend to spend time on the applicant's version, because all she says is, she gives a version, the lordship can accept that she's in custody now. That your lordship must accept. You can accept that she says she's in unlawful custody. That your lordship can accept. And they don't disagree with that. How she finds herself in unlawful custody is for what your lordship will look to the respondents to see what they say. So, my lord, there are various aspects, and perhaps I should just start off by telling your lordship there are three affidavits from the respondent. One by Brigadier Shibiri. That starts on page 56, 57, and that's on behalf of the first, second, and third respondents with a number of confirmatory affidavits. There are many aspects of the affidavit with which we don't have a problem with. Then there's an affidavit from Matthews, and there's the affidavit from the third secretary on behalf of the sixth respondent. But let me turn to Brigadier Shibiri's affidavit and develop some ideas. On page 62, he has a heading, Admission of Hearsay Evidence. We have no difficulty with any evidence that he puts up, which he suggests is to be admitted under the Law of Evidence Amendment Act, Section 3(1)(c). No difficulty. The lordship can have regard to it. Then he starts off introduction on page 64, and I do wish that the court could flip through it with me, because there's some important development that he suggests. He explains what the applicant's case is, etc. On 6th of April, she was arrested and abducted by SABC in Tanzania. He denied it. Let's accept his denial. Then we go on, and he talks a lot about Esther and the coffins and exhumation and escape from prison. All very interesting, but nothing to do with this case. And he talks about, importantly, what the DPP wants to do with the applicant. There are provisional charges identified against her, fraud, etc. That's on page 67, 68, defeating the ends of justice, etc. Then, on paragraph 35, he explains that he now tells the court that she was arrested at Lensera Airport by SABC. So what SABC does is this. It goes to Tanzania, an eight-member team, I think on the 8th of April, and they have, and importantly, I use this word, my lord, deliberations with their counterparts. That's the word that I'm going to come to. He uses the word deliberation. But they take no action. SABC takes a hands-off approach. We're not touching this. We're not touching with a barge pole. Because we know, and the Tanzanians have told us, we will not hand over anybody to the police, because that could be regarded as a disguised extradition. So SABC, hands up. We're not party to this. We're just looking at hand over business. That's what they say. That's the theme of the affidavit. We will read that over and over and over. We were When did SAPS act? The moment they arrived at Lanseria Airport. Into the morning of the 13th of April. And they had left just after midnight on the 12th. And your Lordship has already pointed out that the notice to the prohibited immigrant was issued on the 12th. And yet, 8 hours later, they're being arrested at Lanseria. So they explain all this from paragraph 44 and on. Perhaps it's worth looking at paragraph 46, where he says, an urgent meeting, this is on page 71, was arranged by the SAPS and at the Tshwane Academy in Pretoria, to which Interpol was invited. A meeting was made that a multi-department team from South Africa should be assembled to travel to Tanzania to deal with the matter. On to the next page. The delegation consisting of the following officials, and they tell you, the Brigadier, the Lieutenant General Mosikili, is the Deputy National Commissioner of Police as the head of South African delegates. General Modisi, SAPS Free State. General Van Rooyen, head of SAPS Legal Services. Colonel Mendes, Pretoria Interpol. Somebody from Immigration, Mr. Nishal. Mr. Fulasa from Correctional Services. And he was there because he could identify best because he had personal contact with him at the correctional center here somewhere in Hong Kong. And then, importantly, my Lord, somebody from the DPP, the NPA's office, the Deputy Director of Public Prosecution, that advocate Nagiba, Laxam Nagiba. They boarded a plane on the 9th, they traveled to Arusha. It was a SAPS aeroplane. They arrived very late that night. It was Easter. So they could only interact with the Tanzanians on Monday the 10th. The delegations met at the Tanzanian authority at the hotel where the SAPS delegation was staying, the Kibo Palace Hotel. And then the various issues which they were informed, we have no difficulty with that. Then they say, and this is important, my Lord, because your Lordship will not believe this, under any circumstances. What they say is, it was made clear during the first meeting that the purpose of the engagement, and your Lordship, I've read to you who was there, was to ascertain the identities of the persons reported to have been arrested by the Tanzanian authorities. Then, so let me stop, my Lord, that was the purpose of the engagement. Now we know that can never be the case. The next day, the Tanzanian authorities sent the fingerprints to South Africa for checking. Mr. Matthews says he went down to section 41 to identify the person. That's what section 41 says. So when the police tell you the purpose of the engagement was to ascertain the identities of the persons, that's just not true. On to the next page. Mr. Harris Oshupen, an official from the South African High Commission, and Captain Amos Ralekwa, a police attaché in Tanzania, were part of the meetings. No problem. Now, importantly, my Lord, the first three words in paragraph 53. During the deliberations. Now, my Lord, with respect, this is a court. This is a courtroom. But we can take notice that deliberations mean something. An interaction, and you deliberate. You deliberate what's going to be the outcome of our discussion. That's what a deliberation means. Your Lordship will go into his chambers after hearing argument and you'll deliberate. What should you do with this case? Should you give judgment this way or that way? And if you give judgment that way, what would you say? But then, in this case, it's a bilateral deliberation. On the one side, you've got Tanzanian officials, and on the other side, South African officials, mainly police. And during these deliberations, the South African delegation was asked whether extradition documents had been prepared or were already being prepared and were being prepared for the subject. In response, we, the South African police, informed the Tanzanians no extradition process had been initiated because South Africa, and this is important, my Lord, South Africa's action would need to be informed by the decision taken by the government of Tanzania on the matter. Now, my Lord, with respect, that sentence just flies in the face of every single deportation, extradition doctrine throughout the world and through centuries and centuries. South Africa will decide whether to send an extradition request depending on what Tanzanians tell us. And if the Tanzanians tell us that we'll hand over without extradition, no, we're happy. If they say we've got to bring an extradition request, we'll bring an extradition request. Well, that's not acceptable on anybody's version, in any country, all over the world. Then they go on, if the decision was that extradition route should be followed, South Africa would initiate the process, as it was imperative to the South Africans that proper process should be followed. Initiating the extradition process without having heard from Tanzania what their position would be counterproductive. That just can't be. But my Lord, may I jump? And I'd like your Lordship to hold your thumb at this paragraph and read with it what Matthews and the Third Secretary say. First, on page 172, I've already touched upon this earlier, but this is what happens to the deliberation. The deliberation ends in page 172, paragraph 28. This is what Matthews says. I'm advised that as a matter of international, an agreement was reached. So now the parties deliberate, that the South African police and the Tanzanian counterparts, they deliberate, and they come to an agreement at the end of the deliberation. Those are the words that Matthews puts before the court. An agreement was reached between the South African authorities and the High Commission regarding the deportation. Then the Third Secretary says the same thing. She goes even deeper on page 210, paragraph 13. She says, the agreement between the Tanzanian authorities and the High Commission, and the important words, my Lord, we emphasize the following two words. To deport. So there's an agreement to deport. Back to South Africa was reached at the premises of the High Commission. So this one, it's an agreement to deport back to South Africa at the High Commission. 4 elements to this agreement. I'm advised, she says, that once that happened, the applicant and investor, as a matter of international law, were regarded to have been in the custody of the High Commission on South African soil. Well, I'm not sure what I can say about this, because it is so clear that what the police say, together with what Home Affairs says, and the Third Secretary says, is unlawful on international basis, on the constitutional basis, and as far as the law is concerned. Just on this small little tour that I've taken of 3 paragraphs. An agreement to deport back to South Africa. The agreement was on the High Commission premises, therefore, when that happened, wherever they were, wherever Bester and the applicant were, they were to be regarded, in her words, as to have been in the custody of the High Commission of South Africa. That's just not. Please, with respect. I don't want to be too rude to the Third Secretary, but we have some difficulty with the logic in that. Then, my Lord, I've made this point, that the police tell the court why they went there. That's in paragraph 51. But then one turns to 2 pages later on page 75, where the policeman says, regulator says, Bester was positively identified by the Correctional Services person, Mr. Paulasa. And then in fact 58, this was followed by sending the fingerprint samples taken by the Tanzanians to South Africa to establish the identities of the 2 people. So we know, how do you identify persons who are arrested overseas? You take their fingerprints, this is what the police tells you, and you send it to South Africa to identify the identities to establish the identities of the people. So your Lordship has 2 versions in 3 pages by the police. One, the police were 8 people were in Tanzania to ascertain the identity of the persons reported to have been arrested. That's the one version. That's why they were there, 8 policemen. or 8 people, including mainly policemen, high-level policemen. And the other version, they sent the fingerprints from Tanzania to South Africa. Your Lordship has a choice. Do you believe version 1 of the Brigadier, or believe version 2 of the Brigadier? And then he goes on. Durko offered best known applicant consular services. Both declined. My Lord, let me just deal with an argument now. There is no evidence, no suggestion of evidence, other than a bit of a whisper, that when the applicant was put, she said, good, I can see my children. But when we talk to consent, when we talk to waiver of rights, or waiver of, leave aside liberty rights, but waiver of a right to be extradited, not a word. And what could have happened, but didn't happen, is they could have said to the applicant, look, you're going to be deported, whatever that might mean under Tanzanian law, but we want you back in South Africa. And if you consent to deportation, you're going to be back in South Africa in this strange, unlawful mechanism. Or do you insist on your rights and insist that we bring an extradition application? They didn't do that to her. She had no clue. And I'll tell you why that's important, because in Muhammad, perhaps I should just, and I'm going to turn to it, and 147 of the bundle. And leave aside the death penalty issue. But perhaps I should just read it, because it's not unimportant. I know it's death penalty, but the principle is the same. This is 147 on it. There's a heading, consent to deportation or extradition. And what happened to Mr. Mohammed was, he was a liar. He was in Cape Town on a false visa, asylum visa, liar. He was flipping burgers at Burger King somewhere in Athlone, and he went to renew his asylum visa. He walked into the office, and they said, thank you, Mr. Mohammed, come this way. And they put him in the lift, took him down to the ground floor where the parking was. As one knows, you have parkings. And they said, come this way, and they took him to the car. The next thing is the car was going to the airport. 18 hours later, he was in New York before a grand jury. And the government said he consented to this, whatever it was, extradition, deportation, or whatever it was. And one sees in paragraph 61 on page 147, this is what the government said. The submission strongly advanced on behalf of the government was that Mohammed had consented to his removal to the United States. Whether the removal is characterized as deportation or disguised extradition. And then they say it is open to doubt whether a person in Mohammed's position can validly consent to being removed to a country in order to face criminal charges where his life's in jeopardy. The authorities ought not to be encouraged to obtain consents of such a nature. And then on to the next page, paragraph 63. An indispensable component of consent would be awareness on the part of Mohammed that he could, etc., not be lawfully delivered without obtaining death penalty issues. And then paragraph 64, the onus to prove waiver is on the government. To Blanche and Christian's alleged Mohammed freely, if not eagerly, chose to go to New York in the custody of the FBI agents. Mohammed flatly denies this. So direct and one-dimensional a disputed fact cannot really be resolved in that. Nor is it possible to ascertain a clear preponderance of probabilities in favour of the government version. And then the next paragraph 65. None of the government opponents even suggest that Mohammed was aware of his crucial right to demand, etc. Indeed, there is no suggestion that any of the government officials concerned ever considered this feature, let alone contemplating informed Mohammed. On the contrary, the impression by the affidavit, they were content to let him go, etc. The simple proposition is, on these papers, there's no suggestion that any, open quote, consent by the applicant to be deported back to South Africa in the custody of Mr. Matthews, unlawfully in Tanzania, on the basis of an unlawful section, on the basis of not soil but soil, was communicated to her. She had no clue. Not only did Mr. Matthews have no clue, nor the secretary have no clue, how could the applicant have a clue about these interesting international concepts? Then I'll go on in the Brigadier's affidavit. I'm just concerned of time. I will try to complete my argument by 11:30, if that's within your lordships. I'm just thinking about tea for your lordship.
Yes, now you may proceed, Mr.
Okay.
Mr.
My
Krantz,
lord,
thank you.
so I was talking at page 76 of the papers, and here the police explain what happened. They continue to say, and then, my lord, interestingly in 62, the policeman makes the point that the Tanzanian law was that they had ordered the applicant to leave Tanzania within 3 days. Now, there's no explanation on these papers why she wasn't given 3 days. And the only conclusion that you can come to, my lord, is that the South African had agreed that she wouldn't have those 3 days. There's no other possibility. It just doesn't make sense. Then in 63, I have to read that the delegation was informed that in dealing with deportations, as Tanzania hands deportation to the embassy, South Africa has been ascertained as the country of origin. Tanzania were to hand them to the South African so that they could be removed. Now, my lord, that is not deportation under any international concept, and we've given you the cases. It was decided that they were to be handed to South African diplomats. It doesn't say who decided it. The normal process would require the South African High Commission to engage. Look, I've been doing this kind of law for 30 years. And they say the normal process of deportation would require the South African High Commission to engage the DHA's immigration section. Never heard of that. The first time I've ever seen anything even resembling this normal process. The normal process is you say to the person, all over the world, leave within 3 days. And if after 3 days they don't leave, you may arrest them and you might contact whichever embassy it is and say, listen, we've got your national, they won't leave, please come and collect them. But this normal process would require the South African High Commission to engage South African immigration. It's the first time, and I've done this through every court in this land, in many countries around the world, and in Europe and Africa, I've never seen anything like this. The third secretary then travelled from Dar es Salaam to Arusha to attend the concert relating to the matter. And then importantly, my lord, they know they're in trouble. So what they say is, Advocate Magudumana, that's the NPA person, participation in the engagement as an NPA official was limited to ensuring that the event of the personal identity were confirmed and they were returned, the state would be able to prosecute them should that be necessary. What does that mean, my lord? And I'll ask your lordship, what does it mean that you have an NPA official, he's the deputy director of in Pretoria, who goes there to Tanzania, part of this delegation? Why? To ensure that if identities were confirmed and they were returned, the state would be able to prosecute them should that be necessary. It doesn't make sense. With respect, logic dictates that this can't be true. He was there to consider how to extradite them back. That's his job. That's what they say his job is. And to assist in that context. Then in 66.1, the South African officials would visit the place where they were held. He would not be, the Advocate Magudumana would not be part of the exercise. And then when the handing over by Tanzania to immigration, now they say to immigration, not to the High Commission, to immigration, as when he wasn't present. So now they recognize they have a problem because they have this loose cannon of the NPA hanging around to try to make sure that we can bring them back, prosecute them. This loose cannon is pushed to the side. They made sure he was not present. What was he doing in Tanzania? Then the DHA plan landed late in the evening of, this is paragraph 70, The applicant and investor were handed over to the South African High Commission, not immigration as previously said, but there's another, again, different version. And my Lord, the plane left, paragraph 75, left Tanzania at 23 minutes past midnight. And now our learned friend distanced himself from what happened. Throughout, this is the important sentence, my Lord, that they say, throughout this whole process, the SAPS only provided protection and security service to the Home Affairs officials aboard that plane. So, and that's the theme. SAPS stood back. We, the police, we don't get involved in this. It's Home Affairs business. The Lordship will decide whether that's true or not. And it landed at Lanseria. The SAPS team, which was investigating the case, arrested them. The Lordship knows that in 71. So, my Lord, in paragraph 78.14, sorry, so my Lord, 78.10. Let me just jump back the page on page 82. The applicant was never arrested, as stated, nor was she handcuffed at any point before or during the flight from Tanzania and then the rider by the SAPS. By the SAPS. This entire affidavit by the Brigadier is to absolve SAPS from any responsibility whatsoever. They've got a hands-off approach. They didn't do it. It does nie mate in woorde wet. Wasn't in my presence, therefore it didn't happen. My pro-deo days, I remember those are the words. The witnesses, those policemen. Nie mate in woorde. Torture, nie mate in woorde. The applicant is being unduly, utterly, etc. Paragraph 78.14. Deportation is a unilateral act of the deporting state. The government of Tanzania was within its rights to deport in accordance with its law. In this instance, South Africa was preliminarily engaged to ascertain the country of origin. The process was purely a deportation. Agreement back to South Africa, etc., that just can't be believed. And I turn to Matthew's affidavit. I just want to push through. He says he's the chief director. Your Lordship knows that. That's on page 164, 5. And he goes on where he explains the deportation. On page 169 in paragraph 18, he explains what happened on the 12th of April. I've already made the point that in the second last sentence, or the second last line of that paragraph, liable to be deported back to South Africa. I've got written here a big no. Down the page, paragraph 20, DHA was required to provide airport transportation for the deportation as it was decided that their handover will be done in line with it. Who decided it? They don't say. In the air, it was decided. 21. On the same day, I've read this to you already, my Lord, about the claim. I've read to you paragraph 23, section 41, and then on page 172, what we would suggest is the serious difficulty for the respondent. Look, I do want to turn to some legal points and then turn to the remedies. Some legal points are, and perhaps I should do it, best way to do it should be through our heads of argument. It was a lot of paper, and perhaps I should just flip through our heads and talk to the various chapters that we speak of with reference to the Bible. We start off by saying in paragraph 3, perhaps I should just make a note here. In paragraph 2.3 of our heads, there is a reference to a document, a media statement. I'm not sure, but it may be one of those documents that the sixth respondent wishes to have struck out. But we submit, my Lord, that your Lordship will consider the document in the context of the facts as a whole and decide whether strikeout's appropriate. But I should read you paragraph 2.3, because we say the sixth respondent accepts, I've read this to you already, my Lord, an agreement between the Tanzanians and the High Commission regarding the deportation of the applicant. And then we say that the government has publicly made it clear that the purpose for the delegation being sent to Tanzania was to negotiate and deliberate the deportation of inter alia the applicant. In a public statement of the government on the return of the doctor, the applicant, it is stated that the high-level delegation led by the department sent to Tanzania on Monday, 9 April, has successfully concluded the deportation of the fugitives. It's a public statement. My Lord, we would submit that if your Lordship accepts that as what the Minister said, or the government said, that supports entirely the case of the applicant. Successfully concluded the deportation of the fugitive. What does that mean? Now, a learned friend might ask, well, this must be struck out. Your Lordship doesn't need this in an affidavit. Your Lordship can go to the internet. It's something your Lordship could take judicial notice of with respect. The whole world is watching. The world watches what I say, what your Lordship says, what our learned friends say. When the Minister stands up in a media statement and says something, and he says, the Department of Home Affairs has successfully concluded the deportation of the fugitives, and our learned friends want that to be struck down. Not appropriate when it comes to striking. And then we explain that, as your Lordship pointed out to me earlier, that disguised extradition, the form of deportation, is unlawful under the Constitution, and we talk to Ibrahim. Now, Ibrahim is our true cause of action, the rule of law, which Ibrahim talks to. I don't know if your Lordship has an opportunity to even glance at Ibrahim. It is in our bundle.
I did.
As it pleases the court. And then I just want to make the following two propositions in the next 3 paragraphs. We emphasize that this case does not concern the lawfulness of what Tanzania did in Tanzania. It also does not concern the conduct of the applicant. It concerns an objective constitutional question, that is whether the South African government acted lawfully in being involved in effectively arresting the applicant in Tanzania, and they have to accept it. The Home Affairs say they did it, and forcibly removing and returning her to South Africa following an agreement reached. That's the one proposition. The Constitution regards the conduct of the government as inconsistent with the rule of law, the principle of legality, and the obligation to it. But then in paragraph 5 and 6, we turn to international ideas. In particular, so that, my Lord, the International Covenant on Civil and Political Rights is made with reference to it. It's a United Nations treaty. It's a multilateral treaty. 120, more than 120 states are parties. And importantly, South Africa is a party to it. And that covenant, international treaty, has a committee called the Human Rights. So, my Lord, it's got, may I ask that your Lordship cross off the word council and write the word committee. It's a typo that fell through the cracks. That's in paragraph 5. Not the Human Rights Council, it's the Human Rights Committee. The treaty sets up a committee, not a council. The council's another body. The committee is consistent, and the committee is almost a quasi-judicial body of experts around the world. They sit and they make decisions on individual cases and generalized cases. But they've consistently held that disguised extradition in the form of deportation results in a denial of justice and a violation of the principle of freedom under the treaty. And then in footnote 10, there are some cases, Casiriaga versus Uruguay, Domukowski versus, and some others versus Georgia, Burgess versus Uruguay, and these are 1970s cases. My Lord, we haven't given you the cases in the bundle, but where you wish to have copies of those cases, we'll email it to your registrar. My attorney will hand a hard copy to your registrar. I don't know whether your Lordship can decide. Let me make the offer, and let me ensure your Lordship that by the end of today, my attorney will have provided hard copies to your registrar of those cases referred to intent.
Thank you.
Then we move on to Horse Ferry Road, which is the House of Lords case. And we just want to suggest that it is in our bundle. It's some, quote, big sections from it. Perhaps I should just read it. And it involves, interestingly, South Africa. Perhaps I should just go there right now. 84, 85, 86 of the bundle. My Lord, you will see reference to a United States case called United States versus Alvarez Machete. If your Lordship sees that, in Horse Ferry Road. Horse Ferry Road is ex parte appellate, 1994 House of Lords case. But let me just say what happened with Alvarez Machete, and your Lordship will be interested. There are 9 justices of the United States Supreme Court. And Dr. Alvarez Machete was a doctor for the drug people in Mexico, the drug cartels, and the DEA, the Drug Enforcement Agency in the United States, went to Mexico, injected him, put him on a plane, and now he was facing trial in the United States. And his argument was, I was abducted, or whatever it was, you, criminal court, don't have jurisdiction because of this rendition, abduction, whatever we might call it. The United States Supreme Court said, 6 judges said, you do have jurisdiction. Doesn't matter how you come here, you're here, we will try you. But 3 said, no. And we will give you, perhaps, let me read that to you now, what the 3 said. That you will find on 102, if you might jump ahead, my Lord, I do apologize. This is on 102, you will see what the 3 said, because it's actually very interesting when we think of South Africa's history, including apartheid, etc. What the 3s, and I'll give them it's a dissent. Looking for where the particular paragraph relating to South Africa occurred. I must apologize. But here it is, on page 121. So this is the dissent. The 3 say, in 1992, the significance of this court's precedents is illustrated by a recent decision of the Court of Appeal of the Republic of South Africa, that's the appellate division, based largely on that's the South African Court's appellate division, understanding of the import of this court's cases, the earlier cases, Kerr, etc. That court, the South African Court, held that the prosecution of a defendant kidnapped by agents in another country must be dismissed. S versus Ibrahim. The Court of Appeal of South Africa, and now I say the following words, in a constitutional state as we now have, indeed, I suspect most courts throughout the civilized world will be deeply disturbed by the monstrous decision the court announces today. That's the 6, because the 6 are the court. For every nation that has an interest in preserving the rule of law is affected directly or indirectly by a decision of this character. As Thomas Paine warned, an avidity to punish is always dangerous to liberty because it leads a nation, Matthews, to stretch, to misinterpret, to misapply even the best of laws. The Lordship has it here. On the papers, there's a tendency to stretch, soil, section 41, misinterpret, and to misapply even the best of laws. To counter that tendency, Paine reminds us, he that would make his own liberty secure must guard even his enemy from oppression, for if he violates this duty, he establishes a precedent that will reach to himself. That's what the dissent said. Praising South Africa, praising the appellate division. And now, the appellate division, we go back to 1992. And remember, in Ibrahim, my Lord, it was S versus Ibrahim, he was tried and convicted and given 20 years in jail for being treasonous because he was a member of the ANC. He became a member of South African National Assembly after 94 and became a deputy minister, I think, of international relations, as it turned out. The point simply is that I'm not comparing the African to anybody else with Ibrahim, but what I do compare is the rule of law. The law must not be stretched, it must not be misinterpreted, and it must not be misapplied. It must be dealt with, and in the words of Jibai, strictly and punctiliously. Cross the T's, dot the I's. when it comes to the liberty of the individual. My Lord, I want to end here before I go to the remedy. On page 150 of our bundle, paragraph 68 of the Constitutional Court judgment is Muhammad. I'd like to read this and go to the remedy. The Constitutional Court said the following. This is in 2001. Some 23 years ago. And this is what it says. With paragraph 67, we have fully included not been established that any agreement with Muhammad might have expressed, etc., constitutes a valid consent on the one on which the government can place any reliance. The handing over, the words that your Lordship sees in this case, on the fact of Muhammad to the United States government for removal by them to the United was unlawful. That's what was found. Then, this is what the court says. That is a serious finding. In 2000, South Africa is a young democracy still finding its way to full compliance with the values and ideals enshrined in the Constitution. It is therefore important that the state lead by example. Comply with the law, Mr. Matthews. Brigadier, you lead us. This principle cannot be put better than in the celebrated words of Brandeis and Olmsted versus the United States. In a government of laws, existence of the government will be imperiled if it fails to absorb the law scrupulously. Government is the potent, omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. And the Constitutional Court says that warning was given in a distant era. I think it's about 100 years ago, 1928, nearly 100 years ago. But remains as cogent as ever. Indeed, for us in this country, it has a particular relevance. We saw in the past, that's in apartheid, what happens when the state bends the law to its own ends, and now in the new era of constitutionality, we may be tempted to use questionable measures in the war against crime. The lesson becomes particularly important when dealing with those who aim to destroy the system, terrorism, etc. And then they go on. Here, South African government agents acted inconsistently with the Constitution, with the death penalty point, and then the last sentence. They also acted inconsistently with statute in unduly accelerating deportation and then dispatching the man to a country which they are not authorized to send him. And I turn to the remedy one. The remedy chapter of our case is contained in chapter 5, which is on paragraph 86. Now there is somewhat of a muted complaint by the respondents that the relief changed and didn't. Nothing can be further from the truth. The relief that we seek is consistent with that which we've come to court for. But to the extent that your Lordship scratches his head and thinks, well, this is a serious constitutional matter. I, applicant, have made serious, we as a group have made serious charges and submissions concerning what happened here. You feel that you would wish to make your own tweaks or amendments to the relief. Your Lordship is welcome to do so on the strength of the Modiclip judgment. And that says that where a claimant in such circumstances should not necessarily be bound to the formulation of the relief originally sought or the manner in which it was presented or argued. And that's what that's Harris Day affirmed by the Constitutional Court. Not the Constitutional Court reference is not here. That's not important. So now we turn to what should the remedy be. Now your Lordship, clearly when it comes to the liberty of an individual, is considering a constitutional matter within your Lordship's power. That gives you the remedies set out, gives you and obliges you to the remedies in 172.1 of the Constitution. And 172.1 has two substrands. One is A and the second is B. A tells the court that you must, there's no discretion, you must declare conduct or law, this is conduct in this case, there's no law involved here, that is inconsistent with the Constitution invalid. That your Lordship will see in paragraph 88. You have an obligation to do so. Then, under B, whether you make a declaration or not, you will always have a wide discretion under B to make any order that is just and equitable. So what we've done is we've crafted what we believe to be the order that you must make, the A order, and we've given you the B order, which is along the lines of that contained in the original notice of motion. And that is contained in paragraph 90, where we say in paragraph 1, the urgency prayer that your Lordship sees every day in these courts, and we say that there can be no doubt that this matter is one of serious urgency. And we are concerned that the government tries to swat this away by an urgency point. It's not appropriate in a case like this. But your Lordship will have something to say. 2, this is the 172.1a, perhaps your Lordship could make a note. It is declared, such a declarator, that the applicant's apprehension and arrest in Tanzania by officials of the 2nd and 6th respondents, as well as a subsequent forced return to the Republic, is inconsistent with the Constitution of the Republic of South Africa, 1996, unlawful and invalid. Now, were your Lordship to come to the conclusion that it's not just the 2nd and 6th, that it, well, certainly not the 1st, could be a particular person, we submit that it's the 2nd and the 6th, which is the Minister of Police and the Minister of Home Affairs. They come to court, they tell you what's happened. We would submit that would be the appropriate order. 3, this is the just and equitable order that we would, these 3, that's 3, 4, and 5, are the just and equitable orders along the lines of Ibrahim, with the Constitution backing it up. It is declared that applicants, there should be applicants, and I ask that your Lordship include an apostrophe and an S. Apologize for that. In paragraph 3, applicant's arraignment in the proceedings under the case number 20 capital A stroke 113 stroke 23 before the 4th respondent is inconsistent, unlawful, and void. Then the warrants issued by the 4th respondent in respect of the applicant are inconsistent with the Constitution, unlawful, and that she be discharged from detention immediately. That's the 5th prayer. And we only ask for costs, including the cost of 2 counsel against the 1st, 2nd, 3rd, and 6th respondents, jointly and severally, one paying the other to be absolved. And we would submit, my Lord, that these 6 prayers are the appropriate prayers that should be granted on the basis of the facts set out by the respondents. So
Thank you, Mr. Kitts. I see it is now 20 minutes to 12. Mr. Stellenberg, you will have the floor next, but I think it is appropriate, it would be appropriate if we take a convenience break for 20 minutes. And then we will resume again at 12 o'clock. The court now adjourns. Gentlemen, I hope we are all comfortable now. Mr. Stellenberg, it's your turn to address the court now. You appear for the Director of Public Prosecutions, Free State, for the Minister of South African Police Services, and for the Police Officer, Captain Flyman.
That's correct, my lord.
You may proceed. Thank you.
Well, we will show that the applicant's case, as presented to you this morning, is fundamentally flawed from inception because the point of departure that the applicant uses is wrong. But in order not to put the cart before the horses, we should start at the appropriate juncture, and that is first to evaluate whether this matter ought to be enrolled by you as an urgent application. Now, on behalf of the applicant, the submission was made towards the end of a redress that the respondents attempt to swat aside this case on a technical point, technicality such as urgency, is regrettable. The comment is not justified, my lord, by the evidence. And I don't intend to refer you to all the tried cases. You have our heads and we've set it out. I just want to explain to the court why this is an abusive process. And in exceptional circumstances, the respondents would have been able, quite entitled, to move for the dismissal of this application based on that it's an abusive process, but we don't. We say the court ought to strike it from a roll of cost. Now, my lord would have noted that the applicant, this is common cause, was in South Africa. I'll deal with the rest later, on the 13th, and she was arraigned and she appeared in the Magistrate's court on the same day. What is significant in this matter is that the applicant, for some reason, approaches you and says to the court, well, as far as urgency is concerned, I only appointed my current attorney on the 3rd of May. And that obviously, by implication, means, well, he advised me, and as fast as I could, I made this application. But what the respondents have done is they have appended to the answering affidavit the registers, which shows that the applicant had legal representation and saw an attorney already on the 14th of April. And what the applicant doesn't do, she does not give you an explanation, my lord, with regards to what transpired from the 14th to the 2nd of May. Then, to add insult to injury, the applicant applies on an urgent basis, and she uses what we commonly refer to as a short form notice of motion. There's no indication with regards to any time periods that are afforded to any of the respondents that are cited initially in this matter with regards to when they should oppose it, when affidavit should be filed, etc. And if we calculate it, then the respondents are afforded 3 court days to do whatever they need to do before this matter is on the roll as placed by the applicant. Now, it's right, a party may approach the court on an urgent basis, and when the party itself creates or the rules, the respondent can only complain once it is before court. It dare not comply with the rules that the applicant has made. That is well-established legal principles in South Africa. Now, you've heard, my lord, that this is a important matter and very weighty considerations and constitutional considerations, that only bolsters the point. Bring such an application without affording the respondents a reasonable opportunity to properly oppose this matter, whilst the applicant had from the 14th of April until she issued this application to consider her case and to draw her papers and so forth, because my Lord will not find, it was issued on the 19th of May, my Lord will not find any explanation for the delay and what occurred since the attorney even on the 3rd of May was appointed. Now it is well established, do no variables, that applicant that approaches the court on an urgent basis must determine how urgent the matter is, and then the deviation sought must be commensurate with the degree of urgency. It may not inconvenience my Lord or the respondents more than necessary. But the important thing here is that we are concerned with the respondents' right to access to court when we deal with this matter. We've referred the court in our heads to the Constitutional Court case law on this point, look at Darwin versus Pioneer Foods at paragraph 20 about it, where the Justice Jafta explains that the litigant who wishes to exercise the right of access to court is required to follow certain defined procedures to enable the court to adjudicate the dispute. In the main, these procedures are contained in the rules of each court. The uniform rules regulate form and process in the High Courts. The Supreme Court of Appeal and this court, referring now to the Constitutional Court, have their own rules. These rules confer procedural rights on litigants and also help in creating certainty and procedures to be followed differently of a particular kind of sort. It is important that rules of courts are used as tools to facilitate access to courts rather than hindering it. Hence, rules are made for courts and not courts are established for rules. Therefore, primarily, the function of the rules of court is the attainment of justice. Now, my Lord is well aware that in terms of the Hawker's aviation matter, the Supreme Court of Appeal very succinctly explained that the first thing that the court's called upon to do when faced with an urgent application is to decide whether to enroll it. If it's urgent, then the court will enroll it. In this matter, my Lord, none of the requirements of Rule 12 and none of the established practices pertaining to urgent applications have been complied with by the applicant.
Rule 612.
Rule 612, sorry. And it has two simple requirements that must be met, none of which has the applicant even tried to address in this matter. Now, the submission that if my liberty is taken away from me, and I have to spend a second longer in detention when necessary, that is the start and the end of all, is wrong. That argument might have had some force had the applicant approached this court within a few days after the 13th of April. It does not hold water for an applicant that is quite content from the 13th of April to be in detention. And even after seeing on her version a attorney on the 3rd of May, still waits 60 days. And then issues an application without even attempting to incorporate in the notice of motion reasonable time frames, so that the deviation from the prescribed rules is commensurate with the degree of urgency. This is an abusive process. Prejudice. Today we hear you are referred to passages in the answering affidavits drawn in haste, and you are told that, look how this is stated. Look what's not said here. We all know this from our Prodeo days. Applicant did all the time in the world to do their papers. Respondents, at least the first to third respondents, had to do this under undue pressure. We respectfully submit, my Lord, that the applicant must at least make a case if she wants this matter to be heard on an urgent basis. She hasn't taken the trouble. My Lord can peruse the application. There is scarcely an allegation in that affidavit that deals with that. It doesn't go so far as to satisfy the requirements imposed by Rule 612. So it's not a matter of a technicality, it's a matter of the applicant abusing the process, and she wants to get mileage from it when we are in court today arguing this matter. Our heads are fully address this issue, but we join issue with any contention that the respondents want to get rid of this thing on the technicalities. It's anything but a technicality. If we can then go on to the merits, my Lord. You'll also see that we've just referred you to the tried case law with regards to self-created urgency from paragraph 40 of our heads, which has been acknowledged by the Constitutional Court to be a rule of the High Court that is enforced and enforceable. Now, my Lord posed a question to my colleague with regards to, on behalf of the applicant, with regards to the question of onus, and we are partially probably responsible for the question. We referred you to the, by now, well-known judgment in the matter of the NDPP versus Zuma, where Judge Harms, in no unclear terms, stated that in motion proceedings, the question of onus does not arise. And that is actually found in a very long line of Supreme Court of Appeal cases. But the judgment that our colleagues referred you to in Jijibai, the court actually does, this is also the SEA, does say, and I think it's in paragraph 63, that, speaking under correction, but matters where an applicant approaches the court and the person alleges that he's been detained is an exception to the rule. So there is mention of an onus in applications of this ilk. That onus, however, only comes into existence, my Lord, if firstly, the applicant has been deprived of a liberty. It is ever important, my Lord, to stress that that does not alter the remainder of the foundational values that we know are well established with regards to the adjudication of applications. I just want to give you the correct you can have a look. It's in the applicant's list, actually. I quoted a passage from that judgment from in paragraph 10 of the heads. And you will see they've highlighted and underlined a passage, but just after that, Justice Katsalia says this is also so in motion proceedings, an exception to the general requirement that the applicant must disclose its entire case and family. And I am aware that with my research there was an older appellate division case which basically came to a similar conclusion. But when my Lord studies the Digibar decision, which my learned colleagues rely on, you'll note that in both the majority and minority judgments, the court repeatedly states that the point of departure is the founding affidavit. Now, I must say it's the first time that I've been in a court where an applicant says, I'm not even referring to my own affidavit because I've been caught out that I lied. I've lied to the court. So I'm going to look at what the respondents say, because my version is not correct, it's not true. The applicant approached this court on the basis that she was arrested on the 6th of April in Tanzania by South African police. That on the 12th she was blindfolded and taken to the airport. This, with respect, my Lord, is where we start, the founding affidavit. We don't start by looking at what the respondents say, because we know, and this is trite law, that the respondent is only called upon to answer the case that's made against him. Tilitsani, we've referred you to Tilitsani versus the Administrateur of Transvaal, where the SCA said, you can't expect a respondent, and he need not, when he deposes to an affidavit, worry about what the applicant will do in reply, because he needs to only answer the allegations that are made against him. At page 8 of a record, on or about 6 April 2023, I, the applicant, was in Tanzania. Members of a second respondent, whose full and further particulars are unknown, arrested and or forcefully abducted me. There is the arrest. On the evening of 12th April 2023, I was told that I was going home. And ultimately, I was blindfolded and taken to an airport in Tanzania. Although I do not know the members of the South African Police Service, I can confirm that I was taken to the airport in Tanzania by members of the South African Police Services. Upon my arrival at the airport in Tanzania, I was confronted by 2 members of the South African Police Service in full uniform. They took me to a combi and led me to an aircraft. They both ordered me to get inside the aircraft where supposed to be where I found about 4 members of the South African Defence Force sitting inside the aircraft. I then sat in the aircraft, flanked by members of the second respondent and members of the Defence Force. I must hasten to point out that the 2 female warrant officers' names became known to me, namely Warrant Officer Mjeni and Officer Mbari. They accompanied me to the airport in Tanzania, where we boarded a plane extensively chartered for that purpose by a second respondent, and wherein we were transported to Lanseria. From there we travelled to Bloemfontein Magistrate's Court, where I appeared. At the behest of the first respondent, the matter was postponed in various states. That's the case. But the applicant invited the respondents to court for it. Now that case, my Lord, has been shown to be utterly untruthful. Context, my Lord, is everything. What the applicant does is he sanitizes this matter by not informing the court of the relevant circumstances leading to this matter today, which is quite simply that she and one Mr. Thabo Bester were arrested by Tanzanian police officials in Tanzania because they were there illegally. They entered that country illegally. What the first to third respondent explains to the court, and there's no mention of 2 or 3 versions. It's one version. When we read the papers in context, it's one version. If they received news that Mr. Bester was apprehended there, together with 2 other people, the applicant being one, and the other gentleman being from Mozambique. Mr. Bester is a convicted serial rapist and murderer who escaped from a prison in South Africa. So the police had an urgent meeting, they had a delegation and they went to Tanzania. There's nothing untoward in that. Nothing, and nothing in the papers suggests that that's untoward. They explained to the court who formed part of this delegation. Mr. Matthews wasn't part of this delegation. And they explained to the court what their primary purpose was when they went there. They needed to know whether this is Mr. Bester and the applicant being with him that has been detained. And when they say to the court that they made it clear at the first meeting, during the interaction, that they will get their guidance from whatever Tanzania decides, you are told that you must reject it. But on what basis, my lord? With respect. On what basis was this court rejected? There is no basis. But what is important, my lord, is the following. The applicant, and this is being in motion, you can't reject the respondent's version for being palpably untrue. You must accept it. And at page 82, the first deferred respondents say to the court that the applicant informed all and sundry that she wanted to return to South Africa to her children. She's a mother. She's now been caught in a foreign country in the company of an escaped convict. She's been arrested by that country's police and she's been detained by that country, which they are, of course, entitled to do. And her wish is to return home to her children in South Africa. She's a South African citizen. She says that to everybody willing to listen.
On what page is that you mentioned? I couldn't.
82, page 82.
82.
Paragraph 7.8.9. The respondents go on to say that the applicant was never arrested, nor was she handcuffed at any point before or during the flight from Tanzania to the Republic of South Africa by the South African police service. Now, this is where the remark was made that we all know how police testify, what police say. But, my lord, remember, the police called to the court to answer the allegations in the founding paper. The allegations are that you, Mr. Police, you arrested me. And that is what they are clarifying is. So there's absolutely no foundation, no justification whatsoever for the criticism. So he goes on, the applicants being utterly untruthful with the allegations that he was blindfolded or abducted. Nobody flagged the applicant in the sense that she wishes to convey there were only a limited number of seats on the airplane. And who else is on this airplane? Mr. Bester. That is why precautions had to be taken. He's escaped from prison once. He's now being brought back to South Africa. We're not going to send unarmed people to go and fetch him, because I see in the reply all kinds of questions are raised rhetorically. But the answer to that is quite simple. Let's look at the context of the matter. Then at paragraph 78.13, still on page 82, throughout the whole process, the delegation exercised the necessary deference and allowed the Tanzanian government to undertake its own processes in terms of its own law. And that is also stated previous page. Now, if I can return to the point of departure in this matter, when you read Judge Bai, you will see, my lord, that at a stage, the debate with regards to disguised extradition also reared its head in those proceedings, and both the majority and minority judgments concluded that it was never raised in the founding papers.
Which case is that you are referring to?
Judge Bai, that case would be referred to
Yes,
earlier.
thank you.
It's one that's in our colleague's heads of argument, but you can note the South African Law Report citation is 2009, volume 5, SA 54. And it's a March 2009 judgment by the SCA. They briefly said that might be a legal point, and then both those judgments said, but there's no case in the founding affidavit with regards to that. So we can't approach this matter as the applicant has suggested this morning you should do, my lord. Because what it will do is it will countenance trial by ambush. They did not contend themselves, she did not contend herself to say, well, I actually don't know. I was arrested there. She told the court exactly what she says happened. That is what the respondents came to court to answer. And they have answered. But what we do not find in the founding papers is any semblance of a case by the applicant to say, well, this was actually a disguised extradition. Her case, however, is against the South African police, which says abducted unlawfully from Tanzania. But now that case has been answered, so now we move on. Now, we've just pointed out to the court that when the applicant made this application, it's clear from her founding papers that she foresaw disputes of fact. She says so herself. She has not requested the court for a referral. We also know that motion proceedings are not designed or intended to resolve disputes. That on its own, my lord, is also a basis that this application should be dismissed. But to return to the context, we have a South African mother detained in a foreign country. Things have gone awry. And she's informed she's going to be deported by that government. She's declared illegal. She says she wants to go home. The first deferred respondents tells the court that at no time at all during this process where they were involved did the applicant ever object to getting into that aeroplane, or did she in any manner whatsoever resist. And that accords, my lord, with the fact that she wanted to come home to her children.
Are you saying, Mrs. Stellenberg, that because there was no objection and because apparently she informed that she wanted to go back to South Africa, and because all that happened after the notice of deportation was handed to her, that she must be out of Tanzania in 3 days' time. Does that boil down to the assumption that she was only hitching a ride back to South Africa?
She was hitching a ride. She wanted to come back. She acquiesced to getting on that plane and to flying back to South Africa. And she can. And the case law that said that you cannot consent or acquiesce has been expressly overturned by the SCA. And we want to refer you firstly, my lord, to S versus December. All these cases are well after Abraham.
You mentioned that case in your head.
Yes, we've got all these the cases I'll be referring you to in our heads. You remember this is the matter where the person was brought from Strikeout to South Africa without any extradition proceedings or deportation proceedings having been instituted. But he did so willingly. He accompanied the members of the police willingly. And the court, in this matter, just the facts of the case are just described early on page 439. Says that the first issue raised before the court of quo was in terms of section 106, 1F of the Criminal Procedure Act. That was, of course, stemming from the fact that the applicant was returned to South Africa from Strikeout. The crime was committed in the Republic of South Africa on Friday. The applicant thereafter fled to the Collusion township outside King Williamstown in what was then the independent Republic of Ciskei. There he was found during the early hours of Sunday morning by a posse of policemen from South Africa. He returned with them to East London, where after being interrogated he was formally arrested. Some 2 hours later he made a confession to Lieutenant Swartz, which was reduced to writing as Exhibit M, the admissibility of the confession, which was contested. According to the appellant, he was arrested in and abducted from Ciskei to the Republic. And he then relied on S versus Ibrahim, which we know is a South African case law referred to by our learned colleagues. The court then goes on to consider this. It says the following. It says, in absence of unlawful or improper conduct, in the sense referred to in Ibrahim's case, on the part of any of the organs or functionaries of the South African state, the South African court is not precluded from trying anyone for crimes committed within its borders. There was no unlawful conduct. The special plea was accordingly rejected. That was based on the fact that the court held that the person could and did indeed consent to coming back with the police to South Africa. And in this judgment, the court says that insofar as the case law in Velma and other matters have been impliedly overruled, they do so expressly by means of this judgment. If we can just refer you also to the judgment of S.S. Mahala, that's also in our head argument. It's also subsequent to after Ibrahim. Here the court, the SCA, held that a person can also acquiesce. So it's not necessary for express consent. In this matter, there was actually leg irons that were put on the person who later became the accused person, but it was only a precautionary measure, and that was found by the court to be so. He acquiesced to return with the police, and he was then taken to East London, where he was arrested. SCA says there's nothing wrong with it. What is also important with regards to this matter is that the SCA, and this has not been overruled, this is the law. There was no duty on Captain McLaren in this matter to explain to him the exact nature and details of extradition proceedings in terms of clause 5 of the extradition treaty. says the police were not under any obligation to do so. This is still the law. We'll just refer you also to Isis Mabena, the Tswana judge. We record held where the removal was not by force or deception, without knowledge, and not without knowledge of a government, it would be quite capable of being reported as retained jurisdiction. It's not, it doesn't fall within the category of abductions that Ibrahim is concerned with. Then just you were referred to the matter of Muhammad by our learned colleague. That's the Constitutional Court judgment, where the person was handed over to the FBI. With regards to the discussion under consent to deportation or extradition, each case on its own merits. When my Lord reads this case, my Lord will see that one of the big issues in this matter was that Mr. Muhammad was released and taken to a country that had the death penalty, which the Crown Court obviously had justifiably had a problem with. What they do say in this passage you were not referred to, at paragraph 62, the court says, this is now under the heading consent to deportation or extradition. It's open to doubt whether a person in Muhammad's position can validly consent to being removed to a country in order to face criminal charge where his life is in jeopardy. So there is already a distinguishing factor. The authorities ought not to be encouraged to obtain consents of such a nature. We did not have a benefit of full argument on this issue, and it would accordingly be unwise to express a view on it. We will, without a side, assume in favour of respondents that a proper consent of such a nature would be enforceable against Muhammad. So the Crown Court distinguishes this. It says, I don't think a person can consent to be taken to a country where he will be facing the death penalty. That is a very important distinguishing feature of this case that you have not been made aware of. It is so, the court deals with waiver in that matter later, but there is another point that of this case that's of importance, and that you'll find at paragraph 66, my lord. The judge remarks the following. It says, in the second place, there is a profoundly disturbing circumstance that, on the government's own showing, Muhammad was at no time afforded the benefit of consulting a lawyer. Muhammad was in a very serious predicament, self-evident. Indeed, for him, it was a matter of life and death. In this matter, consular services, including legal services, were offered to the applicant, and she rejected it. She did not accept it. So it's rich for the applicant to come to court on motion and then to argue assumptions and to speculate with regards to matters. But she was afforded an opportunity to make use of consular services to get legal advice. She didn't want to. This accords once more, my lord, when we read the papers, with the wish of a mother, detained in a foreign country, given 3 days to board a ship or an aircraft, leave the borders of a country, to acquiesce, to get on a plane, to come back to South Africa. There is nothing in the papers, respect my lord, that justifies the court to reject that version. None whatsoever. There are speculations, but there is nothing in the papers that justifies you to conclude that the version of the respondents whom I represent is palpably untrue and must be rejected there on the papers. Nothing. The applicant's conduct here is wholly consistent with somebody that acquiesced of her own accord, got on that plane and came back to South Africa, and then somewhere along the line, this brilliant idea going to bring this application. It has also not been shown, established by any semblance, that the South African Police Service has made themselves guilty of any untoward or unlawful conduct. Whether the applicant likes the answer is not the question. They don't need to like the answer. But the version as proffered by the first to third respondents is credible. It's not palpably untrue. It doesn't stand to be rejected. There's nothing untoward with governments and the delegation of South Africa going to Tanzania in light of the hype of this matter, the sensational escape of Mr. Bizzah from prison. He remains a very dangerous criminal. We should not forget that. But when we sanitize our papers and we just leave him aside, when we lose sight of the context with which these matters occurred. The delegation didn't go to Tanzania just because the applicant was there. They went to Tanzania because she was with Mr. Bizzah and another person. And we know what Mr. Bizzah did. So, my Lord, the short and the long of this matter is that the applicant has not argued her own case. She argues a case that she did not call on the respondents to answer today. And she tries to do that on the respondent's case, but she selectively relies on passages in an affidavit, and she asks the court to read things in that isn't there. But we don't read an affidavit like that. We read it in its context. And we read it, we don't take paragraphs in isolation. And when we look at everything, then what happened here is actually quite simple. We know what happened. She wanted to come out, she came out. Unfortunately for her, she was arrested after she was entered legally into the country, and she's now obviously incarcerated and awaiting trial, to apply for bail, and that is unfortunately the consequences of the matter. It's dealt in the papers with the charges, at this stage the provisional charges that she faces. My Lord, if the applicant survives urgency, which we respectfully submit she can't. And on some level, while she has not made a case for it, the court finds that there is a case in terms whereof her arrest was not in South Africa but in Tanzania, and that was unlawful. We would just like to address you on the just and equitable part of the matter. But I do so, my Lord, with a firm belief that this matter should never reach this stage. Section 172(1) B of the Constitution says that the court which declares conduct unconstitutional and invalid may make an order which is just and equitable. Now, it's settled the court has remedial powers under that section, and it's very, very wide. It's expressly not curbed or limited by the Constitution. The leading case with regards to that is the State Information Technology Agency, the SOC matter versus the GMA. That's 2018, volume 2. If you are happy, we'll just hand up a note afterwards, just with the case or references to that. So you don't have to go and look for it more.
Thank you.
The court said the following in that matter. At paragraph 53, it said under section 172(1) of the Constitution, the court deciding a constitutional matter has a wide remedial power, is empowered to make any order that is just and equitable. So wide is that power that it is bounded only by considerations of justice and equity. Now, the consequential orders that the applicant seeks, that's now after the first query, remember, the first query relates to an invalidity, the declaration with regards to the arrest. That's condemnation. The second order is declaring the applicants apprehension, arrest and abduction in Tanzania on or about 7 April, which is wrong. subsequent transportation to the Republic of South Africa and purported arrest and detention to be declared wrongful and unlawful. Then it goes on and says, declaring the arraignment before the fourth respondent under the case, Bloemfontein case number 20, capital A, 11-33 nullity, and setting aside the proceedings, and setting aside all warrants and orders, and declaring the applicant entitled to be discharged from detention and immediate direction of the fourth respondent to immediately discharged. Now, with regards to that, declaration of invalidity, if that should be made, we respectfully submit that the court should take into consideration the following. Abraham is pre-constitutional. Abraham followed on appeal after the person was arraigned and tried in the court, so he was already convicted, and the court then found there was no jurisdiction to do so. We say with respect, my Lord, that the relief that the applicant seeks is not just and equitable. Firstly, the effect of those orders are to divest the Magistrates Court of its constitutionally statutorily ordained jurisdiction. Which is founded in Section 170 of the Constitution, as you know, and grants the power to decide any matter determined by an Act of Parliament. We know the Magistrates Court Act is a creature of that. And you can also have a look at sections 89 and 90 of the Magistrates Court Act with regards to the substantive and territorial criminal jurisdiction of that court. But it basically provides for offences in respect of district and regional magistrates courts where they have jurisdiction in section 90 for areas. Now, the jurisdiction in this matter is a matter of law, it's not of discretion, as was established by the Supreme Court of Appeal in Frankfurt, Longo and others, versus Trifina Mkwena and others. I'm just going to read paragraph 19 to you, my Lord. Jurisdiction is a matter of law and not of discretion or equity. What section 173 and 34 are concerned with. In the present case, jurisdiction is governed by section 21 of the Superior Courts Act, which regulates jurisdiction of various divisions of the High Court over persons in relation to matters. Thus, whether the court has jurisdiction or not is determined with reference to that section only. It has jurisdiction, that is the end of the inquiry. The court does not need either section 173 or 34 to justify exercising it. Similarly, if the court does not have jurisdiction, the inquiry also ends there. If, on the basis of Ibrahim, the court finds that the declaration should be made and that you should consider the other relief that he sought, then we respectfully just ask you to bear in mind the following. The circumstances under which the applicant was brought to South Africa cannot be altered. You don't have a situation that we have at common law with spoliation, where the court says you took possession of an item that you should not have taken possession of because the other person had control of the possession of it. Return it, and then you can come to me and I'll afford you substantial relief. But first return it. My good. The applicant can't go back to Tanzania. She's prohibited. They don't want her there. Is the Magistrate Court then irremediably and forever starved of jurisdiction because the applicant doesn't address this issue? What is the effect and the consequences of relief, she asks? The answer should be in the negative. Would it be in accordance of justice, seeing that you will be faced at this leg of inquiry if it becomes relevant with what is equitable and just? Would it be in accordance with justice and equity to nullify the proceedings thus far before the Magistrates Court in our post-constitutional era? The prosecution of the applicant in the Magistrates Court is based on evidence which the National Prosecuting Authority has at its disposal against the applicant. The evidence is unaffected, my Lord, with the manner in which the applicant was brought to court. What effect will the consequential orders here have and will they not unduly interfere with the NPA's constitutional obligations that it must carry out? We understand the dictum in Abraham, but these issues were not addressed in Abraham, and it has never been addressed by any other court faced with this situation post-Constitution. The applicant does not complain in her papers. He does not challenge the NPA's decision to prosecute her. So, the mere fact that the individual has been arrested unlawfully, does that mean that the prosecution is now likewise unlawful? We know that the SCA has held in the past that even where the machinery of prosecution was found to have been used for an improper motive, that did not necessarily follow that the prosecution should be discontinued. There we refer you to Zuma versus Democratic Alliance and others, and the Acting National Director of Public Prosecution method. The SCA held the view that even in those circumstances, the prosecution of an individual is permissible for as long as there is a reasonable and probable cause for the prosecution. But these are matters that needs to be taken into consideration. The manner in which the applicant was deported, that is fine, subsequently arrested, will not cause the trial or any trial-related prejudice. The applicant certainly did not make such a case. And she also doesn't say that she will not receive a fair hearing from the magistrate court. The proceedings in this matter, my Lord, does not only affect the applicant and the state. It affects the victims. It affects the victims, you'll see when you read with what the charges against her is. People that are entitled to see justice done. These interests have not been addressed by the applicant, but we respectfully submit are of the utmost importance and should be taken into account before an order can be made as sought by the applicant. So the interests of victims of the offences for which the applicant will be charged, as well as the interests of the public to see justice done, are competing interests. Those interests, we respectfully submit, weigh very heavily against the relief other than the declaration of invalidity. We respectfully submit, my Lord, that you will take that into consideration. Lord, so, in conclusion, the fact that there is an onus when a person relies on the fact that he has been denied of his liberty does not mean that the foundational values that govern motions fall away. They do not. One very important value in this matter is, as expressed in Seletsani, that the respondent is called upon to meet a case. We cannot have a situation in law where the respondent not only meets the case, but he refutes the allegations, and then the matter morphs and permeates, and suddenly the respondent must, in argument now, canvass arguments that were never even raised by the applicant and found in papers. It's ambush, it's litigation by ambush, and it's not how our motions work. In this matter, we respectfully submit that there is no evidence whatsoever that the South African Police Service or the NDPP made themselves guilty of any wrongful or unlawful conduct as explained of by the applicant. She, at the very worst, for the first to the third respondent, acquiesced in getting on that flight because she wanted to come home to her children, which we can all understand. That, my Lord, is the short and the long of this matter. We respectfully submit, if you strike the matter from a roll, you should do so with cross attendant upon the employment of two counsel who is employed. The same should follow if you dismiss this application.
Thank you, Mr. Snow.
just take an instruction?
Yes, by all means.
Well, just two short points, if you will allow me.
Yes, yes. Please,
First is
President.
just that there's no proof that there was ever a request for deportation made by the South African government. Just a point that needs to be made. The second is that relief claimed in the notice of motion is against this, and the case is against police, but the applicant an argument challenges the conduct of Home Affairs. You should just take note of that. May it please you, Mark.
Thank you, Mr. Zietsman. The fourth and the fifth respondents have abided by the decision of the court, so they're not opposing. Means that your client and yourself, the Minister of Home Affairs, is next as far as argument is concerned. But I notice it is 3 minutes away from lunchtime. Would it suit you if we stand down till 2 o'clock to hear your argument? Any objections? Thank you, gentlemen. The court will then stand down till 2 o'clock.
Okay, thanks very much.
Thank you, Lord. At the outset, I was handed two agreements. Well, the first is an agreement and the second is an implementation framework between the Republic of Tanzania and the Republic of South Africa. I've provided copies of the two documents to my learned colleague, Mr. Kutz, and they've indicated that they do not object to these agreements being handed up to your Lordship, but we'll deal with the narrow issue in terms thereof.
Yes, thank you. You may do so.
Subject to depending why you're handling it. So I don't object depending why you're handling it.
Yes, my learned colleague will, and he indicated that he will address the issue in reply, the fact that it's been handed up so late.
Well, the question is, I don't object to it being handed in the sense of depending on what my learned friend is going to use them to achieve. I mean, I don't object to pieces of paper being handed up, but if he suggests that there's something in particular, we would reserve the right to comment on that which he would refer to.
Yes, thank you.
Thank you. Well, we've also prepared the supplementary aids of arguments to do the striking out application. We will get to that in the course of argument. But I think the starting point to the whole argument is the replying affidavit, and in particular, page 247. Paragraph 8.1, where the applicant says the following. This application does not concern the lawfulness of the Tanzanian government's conduct. So their application is limited to the conduct of the South African officials, and in our case, as far as the 6 respondents are concerned, that of the Department of Home Affairs. But nothing about the conduct of the government of Tanzania. They accept their conduct. Now, we have in our heads of argument, and I'm going to try not to belabor these points because they have been addressed by my learned colleague, Mr. Snellenberg. The fact that the application initially in the founding affidavit was couched as one of the arrest and abduction of the applicant by members of the South African police force. But subsequent to that, the application has now morphed to one, as we understand it, of an extradition which is disguised as a deportation. And in paragraph 5.2 of our heads of argument, we deal with the processes and the actions of the Department of Home Affairs. Now, it is important to start off by saying that the applicant and Bester was arrested by Tanzanian authorities and declared by them as being prohibited immigrants liable for deportation back to South Africa. Now that cannot be disputed. And the reason why it cannot be disputed is because the applicant never made out a case that she was arrested by Tanzanian officials. Her case is it was the South African police force. But what is more, and I think that would put an end to the argument that she was arrested by the South African police force, is the notice at Annex DHA 7C, which your Lordship will find at page 204. And this is a document from the United Republic of Tanzania, the Ministry of Home Affairs, the Immigration Department. And I'm not going to emphasize this again, but remember, the applicant doesn't take any dispute with what the Tanzanian government did. And in the notice issued, they say in paragraph 2, the above mentioned people, with reference to Bester and the applicant, who were found and arrested in the United Republic of Tanzania for unlawfully entry and present with the country, the act which is contrary to the immigration laws. So there they declare, Tanzania declare, we have arrested. And they also declare the reasons why they've arrested. And obviously the fact that they remain detained by them. We then, in paragraph 5.2.2 perhaps, refer to the notice of prohibited immigrant status. Now, your Lordship will find that in page 202. It's Annexure DHA 7A.
Page?
This is the notice.
Page? Just repeat that.
Page 202.
Thank you.
Now, the notice makes it plain, and this is the notice of the 12th of April. It says the following, with reference to the applicant. You are unlawful present within the United Republic of Tanzania. And then paragraph 4 thereof, you are hereby ordered to leave Tanzania within 3 days by escort. Now the importance of that is, it's not by your free will. Remember, this is not a notice by the applicant himself, this is a notice by the Tanzanian government, who clearly indicates that you will leave the country within 3 days through escort. We then refer to section 25(2)(c) of the Tanzanian Immigration Act, and that act provides that where a person has been declared a prohibited immigrant, as we've seen, has been arrested by Tanzania, as we've seen, she may be placed in custody, that happened, until he or she boards a ship or aircraft or obtains any other means of transport conveying him to any place outside Tanzania. The purpose of 25(2)(c) is that it's not necessarily that an illegal immigrant in Tanzania will be brought before a magistrate, but they may be deported and, importantly, remain in custody. Now, if you remain in custody, it's not your choice as to where you go until you board that ship or aircraft. So then we refer in paragraph 5.2.4 of the heads that the department was requested to provide air transportation for the deportation of the applicant and pester. And that, your Lordship will find at page 169, paragraph 20. Now, if we can turn there, this is the affidavit of Matthews. And he says in paragraph 20, the DHA was required to provide air transportation for the deportation of the applicant and investor, and it was decided that their handover by Tanzanian immigration officers to the South African High Commission will be done in line with Tanzanian immigration laws, the Vienna Convention, and international protocols. Lord, if you turn to the affidavit of Wrong, this is on page 207. This is the third secretary in the employ of the High Commissioner. In other words, this is the affidavit of the High Commissioner. The Lordship must start to read from page 208 and in particular paragraph 10, where the High Commissioner says the following. On the 8th of April, the Arusha Tourist Diplomatic Police informed the High Commissioner about the arrest of the applicant and pester. Then on the 9th, the High Commissioner convened a meeting at the premises of the High Commissioner to discuss the information from the Tanzanian authorities. She decided to send the first secretary, Hadis Ochupeng, to Arusha to render consular services, including interviewing the applicant and pester to verify their nationality. Now this is in line with what the SAPS says. The first plane by them, and on that plane was also a member of the Department of Home Affairs. But it's not the second plane chartered by Home Affairs in this deportation process. Then, paragraph 11, and this is very important within the context of the applicant's argument. It says, on the 11th, Tanzanian authorities informed Oshupeng, or for that matter the High Commissioner, about their decision to declare the applicant investor prohibited immigrants and liable to be deported back to their country of origin, South Africa. Now the very important aspect here is that the decision to deport the applicant back to South Africa, not to any place where she wants to go, but that decision was taken by Tanzanian authorities. And again, to emphasize the point, the applicant does not take issue with that decision. She clearly says, I don't take issue with the actions of the Tanzanian authorities. The High Commission goes on in paragraph 12 to say, the declaration issued on the 12th was in terms of section 23(1) of the Immigration Act, which reads as follows, and then it refers to what exactly is an illegal immigrant within the Tanzanian context. So on the 11th, the decision was made by Tanzania to declare them and to deport them back to South Africa. On the 12th, the notice was issued, which I've already referred to Lordship to. Then in 13, she says, the agreement between Tanzanian authorities and the High Commission to deport the applicant investor back to South Africa was reached at the premises of the High Commission. And she then said the following, I'm advised that once this happened, the applicant investor, as a matter of international law, was regarded to be in the custody of a High Commissioner on South African soil. And we see the arguments with reference to Section 41 and the Vienna Convention. But just the following paragraph, paragraph 14, because whether a person is in one's custody is a factual question, not a legal conclusion, factually. And just the following paragraph, she says the following. Since they were in Arusha, which is 600 kilometers away, the handover to me by the Tanzanian authorities took place at the airport, Kilimanjaro Airport. In fact, this is normal practice because the Tanzanian authorities had to escort them to the airport to ensure that they have indeed departed the Republic of Tanzania. So they were taken by Tanzania from Arusha, where they were initially arrested. They were brought by them to the airport. Tanzania made sure that there is a handover process at the airport to the High Commissioner, from the High Commissioner to the Department of Home Affairs in order to be taken back to South Africa. And all of that was to ensure that they are deported back to South Africa. That was a decision not made by South Africa, but a decision made by Tanzania. If you now turn back to the affidavit of Matthews, and you read that in the whole context, then you'll see Matthews says that on the 12th, remember now on the 11th, the High Commissioner knew that they were going to be declared and that the Tanzanian authority had made the decision to deport them back to South Africa. So on the 12th, the DG in the Department of Home Affairs ordered that transport be arranged, issue notices, the notice that I've already referred to. The transportation was then arranged by the Department of Home Affairs. They say that in paragraph 20, the Department of Home Affairs was required to provide air transportation for the deportation of the applicant investor, and it was decided that their handover by Tanzanian immigration officers to South African authorities in Tanzania will be done in line with Tanzanian immigration laws. Again, when it comes in line with Tanzanian immigration laws is their decision in terms of 25 to deport, their decision that you will be escorted, and their decision that you will be deported back to South Africa. So they then go on in 21 to explain. They arranged the aircraft, they flew to Tanzania. It was with members of the SABC as well as correctional services. Obviously, it was a dual purpose in the sense that Pester was also there. And then in paragraph 25, they explain what happened at the airport. Here they say, 25, the applicant investor was transported by the Tanzanian immigration officers and handed over to Moring, the High Commissioner. Copy of the notice was provided. The notice is DHA 7C, and the applicant was at no stage blindfolded. I think everybody has dealt with that aspect. And they then contend that the DHA acted in terms of the Vienna Convention and Customary International, including the Tanzanian immigration law. Now, if we can just stand still and refer to the handover notice, which your Lordship will find at DHA 8, which is page 205. Apologies. It's page 203, DHA 7B. This is the notice by the South African government, the High Commissioner. It says, the Tanzanian immigration authorities have handed South African nationals with reference to Bester and the applicant, who were detained for violating the immigration laws of the United Republic of Tanzania, to the South African High Commission in Dar es Salaam, Tanzania. The High Commissioner handed them over to the South African immigration officials, who were here to collect the undesirable person who entered the United Republic of Tanzania unlawfully. Now, Lord, that's the process. That is what happened, as explained by the Department of Home Affairs. What the applicant contends is that it was a disguised deportation, but in real fact, it was an extradition. That's their argument. Now, if we can just stand still for a second and refer your Lordship to the case of Mohammed. Mohammed is a case relied on heavily by the applicant, and to a certain extent it assists. Firstly, your Lordship will recall Mohammed was a Tanzanian national arrested in South Africa by our immigration officers with the assistance of the FBI. So the FBI was involved in the process to arrest and to interview them and so forth. And ultimately, South Africa decided to deport Mohammed to the United States to stand trial there for the bombings of the embassy in Dar es Salaam. And the Constitutional Court was then called to answer various questions. One of them was whether the deportation was valid. And in paragraph 28, they explain the principles or the distinction in general terms between an extradition and a deportation as follows. Extradition involves basically three elements, and we've seen this in here. The acts of the sovereign on the part of the two states, a request by one state to another state for the delivery to it of an alleged criminal, and the delivery of the person requested for the purpose of trial or sentence to the territory of the requesting state. The deportation is essentially a unilateral act of the reporting state in order to get rid of an undesired alien. The purpose of the deportation is achieved when such alien leaves the reporting state's territory. The destination of the deportee is irrelevant to the purpose of deportation. But one of the important distinguishing features between extradition and deportation is therefore the purpose of the state delivering act in question. And that's the state delivering, in this case, Tanzania, and the purpose for which they delivered. Where deportation and extradition coincide in effect, difficulties can arise in practice in determining the true purpose and nature of the act of delivery. What the applicants want your lordship to do is to make a decision as to what the true purpose of the Tanzanian authorities was in deporting the applicant. That, with respect to your lordship, cannot do. For two reasons. Firstly, because your lordship doesn't have jurisdiction to do so. But secondly, because the applicants on their own version don't take issue with that. They say this case does not concern the actions of the Tanzanian authority. So just to conclude, Mohammed, the Constitutional Court said in Mohammed, in this particular case, it doesn't really matter whether this was a deportation or an extradition. Because what the court did is it looked at the Aliens Control Act. And that was an act which is applicable to South African home officials. Because, and this is a clear distinction between what we are doing here and what happened in Mohammed. In Mohammed, there was a decision by South African authorities to deport Mohammed to the United States. And the question was whether that was valid. So, in considering the Aliens Control Act, the court referred to Regulation 23 because Section 54, which dealt with deportation, didn't provide an indication whether the deporting state had a decision with regards to which state to deport to. But Regulation 23 said the following, that dealing with the destination of such removals, it reads as follows: any person to be removed from the Republic, this is now South Africa, under the Act, shall, if he or she is the holder of a passport issued by any other country or territory, be removed to that country or territory. And if he's not the holder of such a passport, he shall be deported to where he has residency and so forth, which is not applicable. The important feature in Mohammed is that the United States was not such a country, so therefore the officials of the Department of Home Affairs didn't have authority to decide to deport Mohammed to the United States, and because of that, their actions were unlawful. Your Lordship will find that in paragraph 34. Here, what we have clearly on the papers is a decision by the Tanzanian authorities in terms of their act to deport, and not to deport to anyone, but to deport the applicant who was in possession of a South African passport, although she had three. One was valid. But to deport her back to South Africa. My Lord, if it stands firm, and we respectfully submit that it should, that the decision was made by Tanzania to deport, that it was going to be through an escort, not what the applicant decides, and that it will be back to South Africa. And the applicant doesn't take issue with any of those. And she can't. It would appear to us that her case boils down to this. The Lordship must find that the deportation was not a true deportation, irrespective of the actions of Tanzania, that there was collusion between the South African government and the Tanzanian government to somehow make this look like a deportation, but it's not. It's an extradition. And in doing so, the argument is that you must solely look at the actions of the South African government, because we are happy with what Tanzania did. But that cannot be. Because if their argument is that an extradition is not a unilateral act like deportation, well then they must take their argument further that the Tanzanian government colluded with South Africa to achieve this. And they don't. So on that score, this whole argument of a disguised deportation we submit cannot succeed. There's a different reason why it cannot succeed. That's just because simply, initially, the applicant made no case out whatsoever that that is the position here, that there was collusion. They jumped on the bandwagon simply because Matthew says there was an agreement to deport in paragraph 13. If you read 13 correct, the agreement was to deport back to South Africa. Now, Lord, we've handed up the two agreements. And the argument is simply this. There's nothing sinister about the fact that there's cooperation between the South African Department of Home Affairs and that of the Tanzanian government. The agreement, and I will refer your Lordship to Article 5. It's under the heading Combating Illegal Migration. It says the parties, the two governments, shall take measures to combat illegal migration and cooperate with regards to deportation processes and procedures. So, the fact that there was cooperation between the two governments doesn't make this a reference to an agreement that we will deport. It doesn't make it a disguised extradition. Now, I informed my learned colleagues I will foreshadow the argument probably as to why the agreement is so late. The agreement that I referred to, my Lord, I say again, there was no case made out in founding that the South African government must combat an argument, or if I say the South African government, the Department of Home Affairs, must combat an argument of a disguised extradition or disguised deportation, which is in fact an extradition. So, Lord, we say, if your Lordship considers this matter, and your Lordship exercise jurisdiction over the actions of the Department of Home Affairs, that, in our submission, is limited to the actions of the 12th and the 13th by chartering a plane where there was a request from Tanzania to support the deportation back to South Africa, to provide the transportation. We submit there's nothing unlawful in that. The cooperation between the governments, there's nothing unlawful in that. And if you properly read the affidavit of Murang as to what happened at the airport. It was simply the applicant investor was transferred from Aratusa by Tanzania, not by South Africa. They were brought to the airport. There they were handed over to the High Commissioner through the diplomatic relations, and from there to the department who had chartered the plane, so that the decision by the Tanzanian government to deport the applicant back to South Africa can be fulfilled. And they say it in so many words that the Tanzanian authorities were there to make sure that they leave the territory of Tanzania. So on that basis, we submit that the actions of the Department of Home Affairs weren't unlawful. This was not a disguised deportation. The decision to deport, the destination to where the applicant must be deported, was all made by Tanzanian authorities, and that is not attacked. My Lord, we've also prepared the application to strike out. I'm not going to go through the case law that we referred to there, but what we say in paragraph 3.
Before you go there, Mr. Zitzman, you handed me 2 documents. The one is the agreement with which you have dealt now, Article 5, but there is another one, implementation framework for this agreement. Do you want to refer me to anything in that document?
Lord, insofar as the implementation is concerned, it also in Article 5 deals with combating of illegal immigration. It, in essence, is the same as it refers to cooperation between the countries in order to streamline that process and to effect a deportation.
I see. Thank you.
Lord, insofar as the application to strike through is concerned, we refer in paragraph 6 and 7 to the statements in paragraphs 45 to 41, sorry, 35 to 41 of the replying affidavit, where the applicant all of a sudden deals with the media statements by various government authorities. And we say the reason why she does that, and rely on those, is to clearly indicate the intention of the South African officials involved. It's mainly police officials who made statements there. But that, we submit, is new ground, because initially no case has been made out in founding as to why the process was a disguised extradition. And then in paragraph 10 of our heads of argument, with the supplementary heads, we say that the evidence referred to in paragraph 54 of the replying affidavit should also be struck through. This is with reference to the applicant bringing an application in Tanzania. Okay, Lord, can you just share with me a second? Yes, this was an alleged instruction to a lawyer, an advocate Sambu, to bring an application to declare my detention unlawful. We say there's no evidence in the founding papers. If your Lordship reads the founding papers, what she says is, I was arrested and abducted by the South African police. There's no mention whatsoever. And insofar as that might be an indication to her bringing an application within the 3-day period, we simply don't know, but we say that that's all new matter that should be struck out of the affidavit. My learned colleague for the applicant has indicated that they don't really take issue with the striking application. I'll leave it at that. Look, there was another argument made by the applicants, and this was with reference to the 3-day period that the applicant allegedly had. Now, not only has she not made out any case to say, what I wanted to do within the 3 days afforded to me was to do A, B, C, and D. There's no evidence of that. But let's say she did. Let's, for a moment, just assume that she wanted to bring an application to challenge her arrest, and it can only be, in terms of the 3-day notice, by Tanzanian officials, and her detention by the Tanzanian officials on the basis that she's an illegal immigrant. All of that deals with the interpretation and the lawful actions in terms of Tanzanian law, to which your Lordship respectfully doesn't have jurisdiction to entertain that. So that doesn't take the matter further. It's simply a matter to which your Lordship doesn't have jurisdiction. Lord, we also stand by the allegations in our heads of arguments insofar as urgency is concerned. My learned colleague, Mr. Snellenberg, has addressed urgency, and I'm really not going to regurgitate those arguments simply by stating that we stand by the allegations insofar as our founding, not founding, the heads of argument are concerned. We submit that the application must be dismissed with costs to counsel. Lord, may I just take an instruction?
Yes, you may, certainly.
As a conclusion.
Thank you, Mr. Ziesman. Mr. Katz, I do not know how you want to structure your reply. You informed me in chambers when you came to meet us that Mr. Reinders would deal with the aspect of urgency. I do not know whether you want him to first address the court in reply on the urgency or...
No, I suppose because the argument is developed the way it has, it would probably be preferable to me to deal with everything.
Thanks.
It's a piece of paper. My Lord, I want to deal with urgency up front and demonstrate that far from the allegations made by our learned friends on urgency on the basis of facts that they put up, the case is far weaker, not just on urgency, but on the pleadings point. So they have complained that we didn't, in our founding papers, put up the notion of disguised extradition, etc., etc. But when one has regard to the annexures to the founding papers, two things will become clear. One is they have played possum, and if they have created the urgency, and two, my client, bearing in mind what the Home Affairs have said, or DPP has said, not just the police, was perfectly entitled to come to court to deal with it the way she did. May I just hand up an extract from Silver versus Minister of Safety and Security, 1997, Volume 4, SA 657W. It's an extract, and we put it in our heads of argument to show why the deprivation of liberty must be for no longer than necessary. Every second counts. And I'd just like to read a couple of the paragraphs because it has a resonance to what happened in far as this case is concerned when it comes to the annexures to the founding papers. Heather J., as he then was in the WLV, 1997, says, now it seems to me on the papers before me the applicant has made up what appears to be a prima facie case for unlawfulness of the brother's detention. Whether that be so or not, the onus is on the respondent, as the department, it was Home Affairs, detaining the brother to justify his continued detention. Were this a normal case, that is a matter of some commercial expediency or matter involving something less than the freedom of the individual, I would have no hesitation at all in granting the postponement that has been sought. However, a detained person has an absolute right not to be deprived of his freedom for 1 second longer than necessary by an official who cannot justify the detention. I have by reference to the founding affidavit referred to the attempts, and this is important, my Lord, that were made on Friday, the lack of success that was visited upon the attorney's contacts with the Department of Home Affairs. There are two aspects to this, and I just want to emphasize this when it comes to the letters that I'm going to refer to. From the point of view of the Department of Home Affairs, it seems that if the officials cannot take the necessary steps to deprive a man of his liberty acting within their powers under the Act, as may be, and then place themselves, bona fide no doubt, beyond reach of the administration of justice when they are required to justify that detention. From the side of the police, because now the police were holding the silver person, the police cannot and should not take instructions from another department and detain a person in consequence of those instructions without making absolutely sure they are in a position to justify that detention, and if that justification needs contact with the officials of the other department, that they are in a position to do so. I do not think the liberty of the individual can depend on whether the wheels of state administration run smoothly or not. The liberty of the individual must be sacrosanct in these courts. I don't know whether Your Lordship wishes me to hand up the
Yes,
extra.
please, thank you.
Now, may I turn to the letters that were written? So attached to the founding affidavit, there are letters written by Mutlong attorneys to the police and to the DPP. The letters start on page 31. There are three letters that Your Lordship will have regard to. On 31, on the 12th of May, Machini Mutlong Incorporated writes to Lieutenant General, National Commissioner of Police. Let me say, there has been no answer to this letter. And this is what he asked for. We hold there's various things about what our client was arrested in Tanzania and brought to South Africa on a privately chartered aircraft. We hold instructions to demand the following: the process and procedure invoked to secure the arrest of our client in Tanzania, the processes leading up to the transportation of our client from Tanzania to South Africa, the details members of National Commissioner who participated in the operation from the arrest in Tanzania to the transportation of our client to South Africa, certified copies of the applications, etc. Whole list of documents. Then, day before, on 11th of May, Mr. Mutlong writes to the Director of Public Prosecutions, Free State Province. We refer to the above matter. We consulted with our client, taking full instructions. They want the warrant of arrest, and then on the next page, it's page 34, arrest of our client in Tanzania. It is common cause our client was arrested in Tanzania. However, the processes followed in securing the arrest, particularly by the South African law enforcement authorities, including any other parties involved there, to remain elusive. Demand. It is against this background we demand 3.1. The processes and procedures invoked to secure the arrest of our client in Tanzania, certified copies of the applications, including documents to effect such arrest. And an answer to that is given on the next page 36, where the DPP says, page 36, it is unclear what you mean by the type of document, type of warrant. The warrant was held and handed in court. It is further not clear from your letter under which provision and or legislation the remand is made, or the request for demand is made. Despite the above, it can be mentioned that accused number 4 was arrested by SAPS on 13 April 2023 at Lanseria. She was arrested by the Tanzanian authorities in Tanzania by the Tanzanian authority as being an illegal foreigner. You can contact them if you require more information. The South African police were not involved. That's the answer. So what they say is, we're not telling you. None of the questions of the handover document, the questions of the notice to prohibit immigrant document, not given, despite them having it in their possession, must have had it in their possession, because they were the ones who received it, if not the DPP, certainly, and it was Home Affairs. Or they could have said, Home Affairs have the document. So if we link silver, the urgency point, not for 1 second longer than necessary, to how certainly the police and the DPP conducted themselves in response to a legitimate request for documentations, we would submit that it leaves much to be decided by those parties. Now, the second point I wish to make is there seems to be a botsing between our learned friends. For the police, it said there was a consent. The Lordship has heard this. S versus December. she wanted to see her children. But from Home Affairs, no consent, the Tanzanians decided how she's going to go. Which is it? Consent? Or was it the Tanzanians who decided on the 11th of April when, how she should leave Tanzania? No question of consent. The Tanzanians decided, end of story. That's the one version. Other version is there was a consent. The Lordship, the respondents can't have it both ways. And we would submit that in and of itself leaves some distaste, should leave some distaste with the court about government officials playing possum when it comes to the liberty of a person. Then there is the suggestion, the third point that I wish to make, that I have accepted that my client's version is not true and false. I've never said anything of the sort. What I said was this: Your Lordship doesn't have to consider the validity of my client's version, because on the respondent's version, they make out the case. Very different thing to saying, I accept that she wasn't blindfolded, etc., etc. Your Lordship will decide the facts on the basis of the respondent's version, and that version is uncontested. Mr. Matthews acted unlawfully in Tanzania. There's no basis in law for what he was doing there. I've pointed out the section 41. I've pointed out the soil point. You haven't heard a word, not a word. So your Lordship must accept, we submit, that there was unlawfulness by South Africa in Tanzania, by the Home Affairs.
Can I just make the remark, Mr. Katz,
Yes.
Tongue in the cheek, that this is probably the first case in my life that I've heard where the applicant only relies on the respondent's version, while the respondents only rely on the applicant's version. I haven't seen that before.
No, you probably will never will again.
I hope not.
It is unusual. I can't pretend it's not unusual. But that's what happens when you get a respondent who plays possum when it comes to the liberty of an individual when they request what happened. And the applicant comes to court and gives a version. They reject the version, and now suddenly they come up with their version, which on its face, their version, is bad. If your Lordship goes with our version, I'm not saying your Lordship should reject our version, then of course we win. She was blindfolded and all those kinds of things, abduction. But I don't need to go there. I can go in either version. We win. They say in our version, we can't come home because it's a lie. Not good enough. So that's the second point on that aspect of her version, applicant's version, is if they're correct, both our learned friends, to suggest that your Lordship cannot inquire, these are the words, inquire into or rule on the validity of the conduct of the Tanzanian government in Tanzania. Lordship doesn't have that power, I think. And they rely on a case called Van Zyl versus the Republic of South Africa. It's a Lesotho, South Africa interchange. But what your Lordship can, and we submit must do, is rule on the conduct of South Africa in entering into an agreement with Tanzania. That's the problem. So you have, your Lordship's jurisdiction is limited to the conduct of South Africa, as the South African authorities. And if the South African authorities enter into an agreement with a foreign state, the foreign state might or might not be lawful for the foreign state to enter into the agreement. It's irrelevant for your Lordship's purposes. What is relevant is, did South African authorities have the authority to do so? My learned friend forces me to, he's been banging on about this the whole week, and I now have to. He says, on this point, your Lordship might wish to have regard to page 178 of our bundle, which is a case called the Law Society versus the President of the Republic of South Africa. It's a judgment of the Chief Justice, 2019, Volume 3, Essay 30. Is in our heads of argument quite heavily mentioned. What happened was, there was a SADC tribunal. SADC countries created a tribunal. The tribunal would oversee the SADC countries. And there was something to do with expropriation without compensation of farms in Zimbabwe, and there was a bit of a hiccup as far as South Africa's relations with Zimbabwe went because of this difficulty. So what President Zuma did was he authored a document which effectively disestablished this tribunal. And the Law Society of South Africa ended up in the Constitutional Court and said that when the President signed a protocol to take away certain rights to this tribunal, he did so unlawfully. That one sees on page 177, paragraph 72 and follow. At the bottom of the page, in paragraph 75, the Chief Justice says, a proper determination of the constitutionality of the President's conduct requires that several principles be taken into account. First, the Bill of Rights is not only the cornerstone of our democracy, but also binds all arms of the state and applies to all law. And your Lordship will decide with this Bill of Rights issue, was there consent, or was it the Tanzanians deciding what to do with the agreement of South Africans? It's a Bill of Rights problem. Second, the state has a constitutional obligation to protect, respect, promote. Third, and this is the important point for our purposes, we in South Africa have the duty to honor our international obligations and act consistently with that commitment. And that extends to not undermining or subverting the authority of the tribunal. I'll come back to that in a second, my Lord. Fourth, international that is reconcilable with our constitution is an essential tool. Fifth, we recognize access to the tribunal. And sixth, the exercise of the power must promote. Now, when at the bottom of the page in paragraph 78, and we'll come back to the point that I was going to make about third and fourth points, but at the bottom of the page in paragraph 78, the obligation to respect, protect, and promote the Bill of Rights includes the right of access to justice to not only find application at a domestic level, it is inseparable from whatsoever is done in the name of the state, regardless of where and with whom. Regardless of where and with whom. So when Home Affairs enter into an agreement, and our learned friends can say, and they're quite right, you look at the affidavit as a whole, and you don't pick and choose in this paragraph, and paragraph 13 of the third secretary, you cannot but come to the conclusion, with respect, my Lord, that there was an agreement between the South African side and the Tanzanian side after deliberations. Those are the words. Now, I made this point, my Lord. Third, we have a duty to honor our international obligations and act consistently with that commitment. The first document that we've given you in the bundle, which I haven't mentioned, on page 1, is the SADC Protocol on Extradition. And that's the document that the two states involved could have, and we submit should have relied upon in dealing with this particular applicant. And your Lordship will see, just to complete the picture, that on page 19, on the 3rd of October 2002, done in Luanda, Angola, 3 original texts in English, French, and Portuguese languages. On the right-hand side of the page, one sees Republic of South Africa, and there's President Mbeki's signature. Immediately below that, one sees another signature, that of the President of the United Republic of Tanzania. So these two states entered into a multilateral treaty in 2002, in which they agreed that there would be certain processes, bearing in mind what is set out on page 4, noting with concern that the escalation of crime at both national and international levels and the increased easy access to free cross-border movement enables offenders to escape arrest, prosecution, conviction. Convinced that the speedy integration amongst the state parties, SADC, they seek to create and sustain conditions to eliminate any threat to the security, to make cooperation in the prevention and suppression of crime more effective, bearing in mind the establishment of this treaty will greatly enhance the control of crime, and then they enter into it. And our submission is a simple one. They have this treaty between them. It was a binding treaty between South Africa and Tanzania. They had a good faith obligation, made this in our heads of argument, to comply with that which they had entered into between themselves. Our learned friends don't deal with it. They say, look at the affidavits as a whole. Affidavits as a whole don't mention this at all. So we submit that what happened here was clearly outside the Strategic Protocol on any level, so that is a problem for our learned friends. Now, I need to turn to December. S versus December and the question of the consent. I ask that your Lordship take into account two aspects, and I'll come to one of the two aspects in a second. The first aspect are the facts of December, and we submit that, well, I'm going to make 3 points. The third one your Lordship might have a smile about, but the first aspect is the question of consent. The Appellate Division found there was no violence of any sort, and the appellant willingly consented to return with them to East London in order, why? Not to be arrested at Lanseria, between London, to assist them in their further investigation. He was not, so they insist, a suspect because they possessed no information at that stage which incriminated him in any way. And your Lordship will put that comment and you will contrast it with what was the NPA doing in Tanzania? Investigating whether there was a crime, having as in the prosecutorial sense. That's the first aspect. The second aspect is the Lordship will not find, we submit, on the facts as they are, that the applicant consented, as was done in this case. There are 4 points. The third point is, it seems to us that December and the rejection of Willem is wholly inconsistent with Ibrahim. It's an aberration. Prior to the Constitution, and it's not appropriate under the Constitution that that type of thinking can be adopted, bearing in mind all the arguments made. The fourth point, I think it's not one, is this, and this is why I said I suggest your Lordship might chuckle, is that in Dugard's book, the comment is made about S versus December, and that your Lordship will find at page 190 of the bundle, where it is criticised. And perhaps I should just read from the two paragraphs, and your Lordship can make of it what you wish. The philosophy expounded in S versus Ibrahim was applied to relations between South Africa, Ciskei, and Botswana, which remained nominally independent until 1994.
Okay.
So you've got me, my Lord?
Just a moment. You're reading from 190.
Of the bundle?
Yes.
It's page 322 of the book.
Yes.
It's an interesting spin on where December comes from, and Mahala as well. So you've got number of the philosophy. It's on the left-hand side of the page.
Yes, I see. Right.
Expounded in S versus Abraham was applied to relations between South Africa, Ciskei, and Botswana, which remained nominally independent under South African law until 1994. In Tanzania, it's a case that we rely on, Velum and Base. The failure of the police forces of these territories to respect each other's borders and to follow proper extradition procedures for the rendition of fugitives was condemned and the exercise of jurisdiction refused. In a number of other extraordinary decisions, however, both the lower courts and the AD condoned these cross-border arrests, police deception, and the refusal of the respective police forces of these territories to follow extradition procedures. And then now's the comment by Dugard. And this is what our learned friends rely on. And we submit it's not appropriate in the post-apartheid society. He said, this is what Dugard says. The failure, and I have to admit that I'm one of the authors of this chapter, so neither can I. The failure of courts, including the Appellate Division in Mahala and December, to accept the collection or apprehension, if not formal arrest, of a fugitive by the South African police in the territory of Ciskei or Botswana had been a violation of another state's territorial sovereignty and therefore contrary to the fundamental jurisdictional rules proclaimed in the Lotus case, 120. That's the famous case of a ship, which the Lotus was a ship, SS Lotus, and the question was which territory was being. The question was, where could one have enforcement jurisdiction? Leave aside. can only be explained, my lord, on the grounds that these courts did not actually believe that Ciskei and Botswana were genuine, sovereign, independent states. Let me read that again. Can only be explained on the grounds that these courts did not believe that Ciskei and Botswana were genuine, sovereign, independent states. While it is possible to sympathize with this judicial cynicism about the independence of the homeland states or Bantu states, particularly as the political decision to re-incorporate them into South Africa had already been made at the time of the judgment, is it unfortunate that the judges did not fashion a rule premised on the limited sovereignty of Ciskei and Botswana. Instead, we have a number of unreasoned, uninformed decisions which take no account of the basic principles of international law that seek to limit the law and philosophy of S versus Ibrahim. And we would submit, my lord, that your lordship, unfortunately, or however one can, is bound by Ibrahim in the fullest sense of the word. These are aberrations of the law. So what does Ibrahim say?
Just read that. The one solution is for courts.
Lord, I'm told to read the next sentence. The only solution is for the courts of post-apartheid South Africa to repudiate these decisions as judicial aberrations applicable only to the Bantustan states and not to relationship between South Africa and foreign states. Now, what does Ibrahim actually say? Because we've been talking about it, but it's important that we look at what it actually says. And our learned friend for the police, in our view, takes a line and strikes through in holus bolus what it stands for by suggesting that even if, very hard to argue against, even if there was unlawfulness in the removal, that the trial should continue against the applicant. And let me say why. On page 41 of the bundle, the appellate division describes what Ibrahim sought. He said, next to the letter B on page 562, it is said, or just below B, voordat hy op die aanklagte gepleit het, is 'n aansoek deur hom aangehoor in gevolge in kennisgewing van mosie, waarin die volgende bevelle aangevra is. You see that, my lord? And there were 5 prayers, 4 substantive. Those 4 prayers are the same 4 prayers that we seek today. We've modeled our prayers on the appellate division's prayers, where they describe the prayers that were sought by Mr. Ibrahim in those paragraphs. And then, if one turns to the end of the judgment, and your lordship knows what happened, it's said in the gevolgtrekking, which is the conclusion on page 63, where the High Court, which was Daniel's J, in die uitspraak van die Hof akkoord derhalwe verkeerd. Anyway. And what he said is this, at the bottom of the page, 584I. This is the important proposition that I'm developing on. Appellant's aanklok moes geslaag het. I understand it, the appellant's application should have succeeded. Hy was destyds geregtig op die bevelle aangevra in paras 1 tot 4 van die kennisgewing van mosie. He was at that time entitled to the orders that he sought in paragraphs 1 to 4 of the notice of motion. Your lordship will correct me if my Afrikaans isn't accurate.
Yes, no, that's no problem, sir.
My accent might leave something to be desired, but I hope I get the interpretation.
Yes, but maybe you can just refer me again to the page that you are.
So I'm on page 584. So it's page 63 of the bundle.
Yes, thank you.
At the bottom of the page, the appellate division finds that the appellant's aansoek moes geslaag het. The applicant's...
Isn't that 61? Because my 63...
63, sorry. 63... 63. That's 63 of the bundle. So of the bundle, my lord. Of the bundle of authorities.
Yes, this is what I have here before me. But are you referring to the paginated number 63, or are you referring...
The paginated 63, and in the case itself, oh, I see. My learned junior also has a
63 in
different
my bundle is the case of Vellum.
page. Yes, my lord, there seems to be something has gone wrong. Well, your bundle then, my lord, will be... My lord, did you see the paragraphs 1 to 4? Which I'll have to turn back. I'll have to use my... Okay, so paragraph... No, it's 63, man. It's important, my lord, that we get this right, because this goes to the crux of remedy and conclusion. And at 63, the handwritten 63 on the top right-hand side, mine is just Vellum. Oh, you must have had it. You know what happened, my lord? If you turn to 63, 64, and I turn over the next page, I get to 51. So it's the earlier 63. You turn back to 51 and you go a page before, you get to 63.
Yes, that is a strange way of...
Late at night. I'm not pointing.
Well,
Yes.
incidentally, my bundle doesn't go to 51 after 63.
After 6, no, my lord. The earlier,
Goes
No, no.
63, 64, 50.
yeah, it goes 63, 64, 50.
Yes, but amongst all those numbers, where should I look now, Mr. Khan?
63.
63.
But the earliest, there are obviously two
Of
63.
Ibrahim. Tell him to go to Ibrahim.
Go to Ibrahim, my lord. Ibrahim. Go to Ibrahim. You see, my lord, what's happened is there are now two 63s. Because what happened was, it went 63, 64, 50, and the number started again.
Yes.
I want you to go to the earliest 63.
So you're referring to the page 63, where the Ibrahim case is published. Yes, I've got it.
But no, I'm a bit concerned because then you would have missed my earlier reference to page 41 of Ibrahim, of the paginated bundle, but with Ibrahim is included in 41. You have that, my lord? I need to start there.
Yes. Yes.
On 41, the 4 prayers are described, 1, 2, 3, 4, which we mirror in our notice of motion or in our draft order. And what happens is the court goes through the facts and goes through the Roman law, Roman Dutch law, and it concludes gevolgtrekking on page 584 next to letter G.
Yeah.
And it goes down a bit next to I. Dit volg dat die verhoorhof ooreenkomstig ons geldende gemeenereg geen regsbevoegdheid gehad het om die saak teen appellant te bewerken. Sy skuldig bevinding en vonnis kan gevolglik nie bly staan. And then the important proposition I wish to make in response to our learned friend for the police's comment about just and equitable relief of the whole jurisdiction question. Appellants aansoek moes geslaag het. That's important, my lord. And then the important sentence, the next one, the key sentence. Hy was destyds geregtig op die bevelle aangevra in 1 tot 4 van die kennisgewing van mosie. That's the important point. That although the court didn't grant 1 to 4, because now he'd been tried, convicted, sentenced to 20 years, it wasn't necessary to give the 1 to 4, they just have to set aside his conviction and sentence. But if your lordship goes back to 1 to 4, you know that the appellate division said he was entitled to 1 to 4, which is what we are asking the court to do. That's what I'm suggesting. So what we are asking for is your lordship to follow binding precedent on the question of what is the appropriate relief. Were your lordship to come to the conclusion that I would suggest anything, including that there was no power to use section 41 or any other section by the respondent, and there was no power to enter into an agreement, and there was no soil issue. But now, my lord, I want to turn to something. It was then suggested that for a whole range of reasons, it was just and equitable that even if my client was unlawfully brought to South Africa, the trial should continue. Your lordship heard that?
Yeah. Yeah.
Now, what happened was, my learned friend, he set out a whole series of factors. Why should she go free, etc., etc.? What about the victims? What he did not mention was rule of law. The rule of law stands above us all. It makes us, and that's key. And that is said by the 4 judges in the House of Lords who rejected the minority in the House of Lords in Horseferry Road, ex parte Bennett, where that same argument was adopted by Lord Oliver of Almerton. And that you will see, my Lord, I hope I get the right page number, on page 90 of the bundle. Your Lordship will see Lord Oliver of Almerton's speech, they called it. On the right-hand side of the page, he sets out all the factors that our learned friend for the police set out to your Lordship, and said for that reason, even though Bennett was brought before the United Kingdom courts unlawfully, the trial should continue. Same reasoning. But the four law lords said, no, it doesn't work that way. And that goes to the Justice Stevens' comment in Alvarez Machine, which I've read to your Lordship this morning, where all of these issues were debated at length. And I cannot but ask that your Lordship have regard to what Justice Stevens said in dissent, again on page 120 of the US Supreme Court, where what he said is, look, South Africa. The Court of Appeal in South Africa, I suspect most courts throughout the civilized world, will be deeply disturbed by the majority. For every nation, and then I emphasize, has an interest in preserving the rule of law, is affected directly by decision, etc., etc. So it's a rule of law issue going back to Thomas Paine 300 years ago. And we would stand by that submission and suggest that your Lordship has no power to grant anything other than the kinds of orders as applicable to our case, that 1 to 4 of Ibrahim would have been granted had he not been tried and convicted. And it's interesting, but that's for another day in a future court which is not bound by the appellate division. And that's how we would suggest that the court considers our learned friend's argument. It's an attractive argument, I have no doubt, but it's not for this court bound by Ibrahim to take a line, just cut through those paragraphs 1 to 4 of Ibrahim. Let the Constitutional Court do it if they say Ibrahim is wrong. As it pleases. Oh, sorry, my Lord, I just want to say one thing about our learned friends handing up those two documents, which are interesting. We have no objection to them being handed up. We scratch our heads as to why they're being handed up now. And I've read them, and they don't seem to help our learned friends for the department. They make it worse. Because there's reference to Article 5 in the main treaty, the Lordship heard that, which is parties shall take measures to combat illegal migration and cooperate with regard to deportation processes and procedures. And then your Lordship asked the very interesting question, what about other documents? The framework. And the framework document doesn't say anything to suggest that Mr. Matthews and the others may visit the country of Tanzania or the Tanzanian resident of South Africa. What it does say in Article 5 of the framework document, that there is a combating of illegal migration and the various obligations under the framework that the parties enter into. But then, paragraph 4 of Article 5, it says receipt of deportees. I want to emphasize, my Lord, receipt of deportees. Where? In their country of origin. Nothing about receipt of deportees in the host country by the High Commission or the Home Affairs Division will be dealt with in accordance with domestic or national procedures. Clearly what this envisages is that when a South African is deported, let's say from Tanzania, in South Africa, not in Tanzania, they will be dealt with in accordance with those procedures. So there's nothing to suggest in these documents that there's any power that South Africans or Tanzanians have respectively to enter each other's countries for purposes of combating illegal migration, etc., etc. I question the status of these documents, because it doesn't seem to me that they're part of South African law. They're out there. I'm not sure whether they're binding on the states. Or importantly, my Lord, there's a question of Section 231, one of the Constitution gives the power to the national executive to enter into agreements between other countries, not law in South Africa, unless it's made an act of Parliament under Section 231 for the Constitution. So, but your Lordship doesn't need to have that as a piece of.
Thank you, Mr. Counsel.
Well, I'm sorry, I don't want the second bite of Jerry. We have 3 submissions, one relating to urgency, which we just want to address. Will be very brief.
Yes.
My Lord, you've been referred to the correspondence to the papers that the applicant appended from page 51. We just want to highlight that the first letter that was addressed is 11 May. That's just shy of a month since she was, you remember, she was brought to South Africa and arrested on the 13th of April. The second is the 12th of May. And then the criticism with regards to the reply at page 36 is of course wholly unreasonable, because this reply that was given here is exactly in accordance with the first deferred respondents version that they've also given to this court. When they say the South African police were not involved in the arrest of the applicant and did not have any jurisdiction to arrest, that is perfectly correct. So the criticism and the attempt to rely on this a month later to say to the court, well, you should actually take a dim view of the respondent's conduct. I'm sorry, my Lord. No. The second issue is that the submission is made that the applicant seeks the same relief that was sought in Abraham, but that is not correct, my Lord, with respect. I ask you to page to Estes Abraham at page 41 of the applicant's bundle. And if you would be so kind to just open
Which
your,
page 41?
41.
Which page 41?
I would have it as the first page 41. It's where it starts with empty estate, Judge of Appeal, where he's busy with his introduction.
Yes, it seems to me we've got the same one.
Yes.
Yes.
And then would you be so kind simultaneously to open your record at page 2, record of the proceedings here,
Yes.
the application. May I just direct your attention to paragraph 3-4 in that, where he's dealing with the orders that have been requested. Declaring that the applicant is entitled to be discharged from his imprisonment and detention at present, pending his trial under said indictment. There is no such period in the current notice of motion. It's not asked. This accords with the submissions that we've made to you, my Lord, and with respect to what we said is not against the rule of law. And it is not correct that the prayer in this application was drafted to accord with these prayers, because it doesn't. There's no, what the applicant moves for is that you should be discharged from detention, you must be released immediately, and that everything be set aside. That's it. So we join issue with the submission that prayer 4 of the Abraham case is definitely not there. Lastly, we've referred you to the Mohammed decision. The Concord dealt with the consent here. So to argue that my Lord, who is constrained by the rule of law and the Precedent, the doctrine of legal precedent, to follow the SCA decisions, that you must ignore S versus December and related cases, where they expressly dealt with this matter, and where the Concord had the opportunity to deal with consent, and the remarks with regards to consent. Remember, we deal with acquiescence, where they say it is to be doubted where somebody consents to be extradited or deported where his life will be in danger. That's the distinction we drew. You can read the discussion here as well. We join issue with the submissions with regards to that and the fact that it's said that the first deferred respondents argument flies in the face. You are bound by legal doctrine of legal precedent, and that's part of the rule of law, with respect.
Thank you, Mr. Snellenberg. Gentlemen, hopefully there will be an understanding that I need to digest all the submissions that have been placed before me today. again read your heads of argument, and then most importantly to pay due consideration to all the submissions and to come to a just conclusion. I do not intend taking weeks to do that. What I intend doing is to deliver judgment in this matter coming Monday, 5 June at 10 o'clock in the morning in this very same courtroom. Monday, 5 June, 10 a.m. in this courtroom, I will deliver judgment in this matter. Thank you, gentlemen. The court will now adjourn.
Rising court. Special allocation of 3 vehicles.